How are you feeling? How long have you been here?
3 months, May 17th.
And what brought you?
That's difficult to answer.
Eventually resulted in your being here in the hospital.
That's difficult to answer.
is the end. There's a noise inside my head of crying people facing death. Is this the end? Is this the end? Oh, I'm burning in the dystopia. There's no place to hide. I'm burning in the dystopia. This is the final time. What have we done to the world? What have we done to the world? I'm burning in dystopia. There's no place to hide. I'm burning in dystopia. This is the final The left seeks power in every way they can. Elected seats influence and calculated mental scruples and CEOs. They expand their cultural control. Soft power whispers shaping their utopian goals. Once in power, they destabilize the norm, creating chaos, making societies swerve. Problems they orchestrate by design, blaming capitalism for the pain, a clever lie. These are the four goals of the world, embedded in actions, words they roll. From pushing equity to Marxist streams, dance on power, scheme and scheme. In every move, their agenda gleams. Remember, nothing's ever as it seems. Next capitalism, they fiercely assail. In every speech, it's the villain they unveil. From racism, patriarchy, they rail. Ain't no, ain't nothing, equity, they prevail. Ushering in their Marxist utopias, the end game. The turmoil and strife they aim to overthrow the old, establish their claim. With the vision, they abolish everything. They need capitalism for the pain, a clever lie. These are the four goals of the world, embedded in actions, words they roll. From pushing equity to Marxist dreams, in the dance of power, scheme and scheme. In every move, their agenda gleams. Remember, nothing's ever as it seems. So, instrumental.
What up, guys? Oh, why am I not in the middle of the screen? Hang on. Hi. Hi, everyone. Hey, Jerry's here. It's been a while. Thank you, thank you, thank you. Sure. You know what? Hey, use it as a business expense, Jerry. I appreciate that. Welcome, New Britain Polly. I'm new here, but a hardcore red pill groiper. Okay, we love our groipers here. Just don't be a dick. Okay? Because I do love groipers. I do, except I love groipers, except when I don't love groipers. You know what I'm saying? Everyone's welcome here. It doesn't matter what your political beliefs are. It doesn't matter if you're a groiper, non-groiper, whatever, but just play nicely. Okay? Don't be a dick. I don't want to make any assumptions, but I know you guys. I see you. I see you in my replies when I retweet someone you don't like. I know what the deal is, but I do love Nick and I do love the groipers, even when they're being dicks, okay? Hey, listen, we had a big victory last night. We had a big victory because last night, for people who don't know, last night we went into the belly of the beast in Spy Stream, and I've been telling you guys all week, I was like, you're not going to want to miss Monday's Spy Stream. Maybe I'd only been telling you guys for 2 days. I think I actually found this Spy Stream on Friday. So maybe I was only telling you for 2 days and not a week. But I definitely was like, you don't want to miss Monday's Spy Stream. You don't want to miss Monday's Spy Stream. You don't want to miss Monday's Spy Stream. And I kept telling you guys, we were going into some big university that everyone's heard of. And it was Harvard. We went into the belly of the beast in Harvard. I got a Zoom link to one of their classes. Basically, this class held a panel. This class, which was a class in activism, held a panel where they brought activists in from all over the country to teach the students at Harvard how to be activists. And so what happened was they had this in the university schedule for their specific department. I found it. I found the Zoom link. I registered for it because anyone in the public could register and attend. It's not like I snuck into something that wasn't publicly available. It was publicly available. I was part of the public that registered and went. And they didn't realize I was recording them. And quite frankly, I never said I wouldn't. And so because it was a publicly available class that anyone could go to and anyone could register for, and it's not like they checked IDs at the door or anything. I used a fake name, but I mean, I wasn't obviously enrolled in the class, so they could have just kicked me out for not being enrolled in the class, but they didn't. So I recorded the whole thing and I put it on the internet. And this class was just as crazy as you think it is. We had a great turnout for Spy Stream last night. We saw them say some insane things. We saw them say insane things like basically they were complaining a lot about the Trump administration going after illegal aliens. They were a couple of them did work for like legal defense funds that were trying to protect illegals from getting deported and stuff like that. We saw one person talk about using fourth graders as protesters. We saw a person talk about abolishing the gender binary and how everyone will be better off if we abolish the gender binary. And at the end, it was so beautiful. At the end, the person moderating the panel, who works for Microsoft, by the way, I didn't know that at the time, but I know that now. The person moderating the panel actually said, "Thank you to the Reagan Fund at Harvard University for allowing us to pay our panelists to come today so that they could get paid for their work." So not only was Harvard, and by the way, the professor of this class, go into the article on the Substack. The professor of this class, his name is Michael Bronsky. Michael Bronsky's official title is Professor of the Practice in Media and Activism. This is a professor of activism at Harvard teaching a class called Power to the People, Black Power, Radical Feminism, and Gay Liberation, 1955 through 1975. So he's a professor of activism teaching a class in activism as a general education requirement at Harvard. The meeting we attended was called Activism in Action, in which they brought recent Harvard graduates back to Harvard to lecture current Harvard students about activism. You're going to tell me that Harvard is not training the next generation of activists? You're going to honestly and sincerely look me in the face and say, no, Karlyn, Harvard is definitely not indoctrinating their students to be activists, when they literally have a professor of activism teaching a class on activism, where they did a seminar about activism, where they brought in and paid, Harvard University paid for this. They paid for activists to come in all over the country to teach their students how to be activists. You're going to tell me they're not promoting activism? Please, bro. Please. So we got some great clips of that. I did post the highlight reel on my YouTube channel, on my Rumble channel, wherever I could post it. I have it, of course, in the Substack article. So Substack is always going to be the primary place you want to go. That is Karlyn, KARLYN.substack.com. Check out the highlight reel. And make sure you share it on Twitter. I mean, we're getting a great response on Twitter. It's got almost 100,000 views so far. So that's pretty great. If you have not yet shared it out on Twitter, please take a second to retweet it, like it. Oh, that's not the thing I want to put in the chat. My computer, for some reason, is not copying and pasting the way I wish it would. My keyboard is not copying and pasting, but I can paste in now. There we go. There's the link over to Twitter. So if you are on Twitter, please make sure, guys, here's what we need to do on Twitter. We need to like every tweet. We need to reply it to, well, when the important stuff, not every single thing I tweet, but when I tweet something, it's important like this. You need to bookmark it. You need to like it. You need to retweet it. You need to quote tweet it, and you need to reply to it. And all those steps matter. Okay, because what we're trying to do is make sure the algorithm is triggered on Twitter so it actually shows people my content. So please make sure you are doing all of those things. Someone also told me, they were like, Karlyn, if you put an emoji at the start of your tweet, that kills your reach. And so I was like, all right, well, in the future, I won't put an emoji at the start of my tweet. Fine. Like, if we need to mess with the algorithm, I'm totally fine with doing that. But I've always put emojis at the beginning of my tweets, and it's always worked just fine. So maybe I'll get more views if I don't put an emoji. I don't know, man. But I am willing to try it, because if I'm asking you guys to like, reply, retweet, quote tweet, and bookmark every single important tweet that I send, I can try to write the tweet without an emoji. It's not really that big of a deal. So I will do that. But I want to do a special thank you out to the Hodge twins. The Hodge twins retweeted it. They retweeted it and they quote tweeted it. So double win from the Hodge twins. They have 3 million followers. I've always appreciated the Hodge twins. Like, they've always been nice to me from the very beginning. They've never kind of been a dick about anything. And so I do appreciate them as sharing the content out with the world. I do believe they're actually, like, they're genuine for what they believe. Like, what I appreciate about them is, like, they're grifters, but they admit that they're grifters. So it's like they're overt grifting. So I don't even mind that they're grifting because they're honest about what they're doing. And I'm like, you know what? Hey, hey, bro, like, do it, like, like, own it. And that's all that matters. It's the grifters that lie about being grifters and pretend not to be grifters that I'm like, nah, you're a phony. But if you're authentically owning that you're grifting and you're just having a good time about it, which I do think anytime I watch their content, I just feel like they're having the most fun, like, on the internet, and it makes me have fun watching them. And so I'm like, you know what? Do it, man. I don't even care. I don't care. Take my money. You're making me laugh. You're giving me value in the world. And so I do really appreciate that. Now, what is interesting, and I mentioned this, I've been doing some live streams on my Substack. So again, guys, make sure you're following me on my Substack, at least as a free subscriber. That is Karlyn, KARLYN.substack.com. I have been doing some Substack kind of exclusive live streams. Today, I did an experiment where I did a live stream on Substack. I interacted with my audience on Substack. I then put the live stream on YouTube and on Rumble. And people are complaining about the volume on YouTube, man. Hey, we'll figure it out. But listen, someone on YouTube said, they were like, oh, I don't know if I can share this because the volume is low. I'm like, you want me to think you're serious about defeating the left, and you're not going to share a video because you had to turn up the volume on your computer? Do you know all the problems we have to deal with socialist audio? Do you guys have any idea the amount of troubleshooting we've had to done with socialist audio? It's called the volume button, bro. So if the volume and something not being technically perfect is the thing that's going to prevent you from sharing important content out to the world, just go away. Go back to Fox News. Go back to Libs of TikTok. Go back to the Daily Wire. Go back to anywhere else. Don't stay here because you're not serious. And I'm really only interested in interacting with people who are actually serious about this problem. And I think there are enough people who are serious about this problem that I don't have to interact with the people complaining about the volume button, okay? Anyway, my point is, I did a live stream over on Substack today, and I kind of talked about this a little bit in that live stream, but I'm going to say it here too. Just as interesting to me is the people who share this sort of information. And again, I really appreciate everyone who shared it. We're going to get up to over 100,000 views on this. That's really, really good. I hope it goes much, much, much higher. But it is always quite telling for me, the people who do not share it, Chris Rufo. Now, Chris Rufo is one of the first people I sent this tweet to this morning. And I know he reads the things I sent him. I know he does. So we are now in a position where Chris Rufo, who has been Harvard's #1 enemy for a year, who's been, for maybe even more than that, who has been complaining left, right, and center about Harvard, who has been on a campaign to get Harvard defunded, Chris Rufo now has direct access to an activism class at Harvard that was taught by an activism professor where the students were taught overtly to be activists. And he doesn't seem to be sharing it so far. Maybe he will. Maybe, he's a busy guy. We can't discount that. But the thing of it is I look at people like, we've been tagging the hell out of Bill Ackman. I just responded to Melissa Chen. Melissa Chen's also complaining about Harvard. So my point is this. Listen, first off, none of these people owe me anything and none of these people owe us anything. I know for an absolute fact that Chris Rufo has shit talked me behind my back because I've heard about it from multiple people. That always made me upset because I never went after him in public. I never had a bad thing to say about him in public because of I am actually, there is something to be said for the fact that he stepped up when no one else wanted to do it. The work he's done, by and large, though I disagree with some of it, mostly has been really, really good and really positive and really impactful. And I do have a certain amount of deference to people who do actually get shit done in the real world. But I think we can all acknowledge and understand that if Chris Rufo doesn't share this information, it is purely a petty personal conflict where he has some issue with me. Maybe it's gossip spread about me on the internet. Maybe it's that he doesn't like my tone. Maybe it's that he doesn't like that I'm not a conservative. Maybe it's that he doesn't like that I won't shill political talking points or follow a frame narrative, because he follows a narrative quite well. He is a brand. He has created a brand and he does not deviate from his brand. But Harvard is definitely within his brand. There is no excuse. And so what I'm saying is that oftentimes when you're looking to figure out if people are serious about something or if they're just doing something to shill a political narrative and eventually run for office and probably get into Congress, Chris Rufo, I think that's what you're doing. They're going to ignore information that is actually really valuable information for their cause because branding is more important. I think it's important that we understand who these people are. I think it's important that we understand who's in this for real and who's in this for image, who's in this for real and who listens to petty gossip and bullshit or engages in these games where if you don't agree with me on Israel, I'm not going to share really important content out to the world that would serve the world, that would even serve me in the point I'm trying to make because you don't agree with me on Israel. Or any number of other things. Maybe it's not Israel. Maybe it's something else. I don't know. But here's what I do know is that it's not as though Chris Rufo is above defending people with gossip. And the worst thing that anyone has on me is I dated someone inconvenient in college. That's the worst thing that anyone has. That I dated someone who went to prison. I firmly believe for something that he didn't do. Because I was there and no one else was. And so that's really the worst thing people have on me. Chris Rufo defended Corey DeAngelis when Corey DeAngelis was outed as a porn star. Chris Rufo hired and then did not fire Christina Buttons after we all found out that Christina Buttons went by what was a hardcore porn star for years, went by the name Rita Lovely. Dozens and dozens and dozens of hardcore porn titles. She still works at the Manhattan Institute. And listen, man, I abhor Christina Buttons because I think she's I think she's a fucking crazy person. And I don't think that she's genuine. And I don't think her work is very good. I adore Corey DeAngelis. I will never hold Corey DeAngelis' past against him because I like him and I like his work and he's always been good to me. He's never done anything to me. So my point here is not that we should be I don't think everyone has a past, right? There's gossip about everyone on the internet. Everyone's had interactions with anyone else. But when I've seen Rufo interacting with James Lindsay and James Lindsay is off his fucking rocker, and Chris Rufo is one of the people that elevated James, by the way, and James has completely shit on all the things that he gave him. But he won't share stuff like this, then I start to have questions about who is genuine and who is in this for real and who is in this for themselves. And I've been very fucking nice to Chris Rufo over the years. I haven't gone after him when other people wanted me to. I haven't gone after him when the Groypers wanted me to. I've always been nice. But there will reach a point where, bro, I spent a year and a half driving James Lindsay crazy. If I want to get at someone, I will get at someone and I will do it slowly and I will do it over the course of time. And if I start to really believe that Chris Rufo is only in this for himself and he's an inauthentic shill, shilling a political narrative, and he doesn't actually care about solving the problems anymore because he's now conservatively ingrained in the machine. He's a board of trustee member for a college that's buying 250 copies of Judith Butler's gender studies book, distributing them to students for free after making a big political show of throwing out all the DEI books. At some point, I'm going to go, yeah, I'm not going to keep my mouth shut about this anymore. I think I've been more than nice. I think I've been more than patient. But when I deliver you a Harvard class taught by a professor of activism, the class is about activism, with an activism panel, when you're screaming on Twitter about defund Harvard, defund Harvard, defund Harvard, they're doing all this crazy shit with the money, and I deliver you direct receipts, and you don't do shit with it, because you don't like the source, you don't like my hair, you don't like my tone, you don't like my attitude, you don't like that there's gossip about me on the internet when you very literally employ a hardcore porn star that was a hardcore porn star for a really long time. I've seen multiple pictures of Christina Buttons going down on many men because I made the mistake of Googling her porn name, which is Rita Lovely, found it all over the internet. That's acceptable. That's acceptable in the conservative machine. Hardcore porn stars pretending to be journalists while not doing any actual journalism. And by the way, I'm not trying to get in at the Manhattan Institute at all. I want to make this very clear. I don't want to work for them. I don't want to work for him. I don't want to do that. I want to make this very clear. This is not trying to get in there because I would never do that because I want to remain independent. But what it is people not allowing narrative and bullshit to get in the way of actually solving a problem. The reason that I started going after James in the first place was he was lying to people about what was going on and it was going to make it harder to solve the problem. And so he needed to be stopped. And now he has gone crazy and all he's talking about is the Jews, the Jews, the Jews, the Jews, the Jews all day, every day. The Jews, the woke right, 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 all day, every day. So now James has stopped lying to people about the left. So that problem is solved. We don't have to deal with that anymore. Whose door am I knocking on next? I've exposed a lot of people in this space for not being authentic. I exposed Dave Rubin for trying to get people fired after October 7th. That ended up in Nick Fuentes' lap just magically. After I talked to a bunch of people who told me Dave Rubin called my employer to try to get me fired, and I talked to more than one source, I maybe magically shot that information out to Nick Fuentes, who then talked about it on his show, and Dave Rubin wasn't happy about that. But I knocked on that door, didn't I? And I will knock on any other fucking door I have to, because unlike most of the shills on the internet, I actually care about solving the problem. And so this information needs to get in front of people. And if there are going to be gatekeepers on the conservative right that are going to prevent this information from getting in front of people because they don't like that I'm friends with Nick Fuentes, or they don't like that I don't support Israel, or they don't like that I won't toe their political narrative, then those people are just as big a problem as the left is. In fact, those people are just as big a problem, even a bigger fucking problem than the left is, because they are the ones standing in our way of actually being productive. They're the ones out there pretending they care about things that they don't actually care about. And it's just about money and image and clout and influence and blah, da, 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 da. How fucking boring. How boring to be so obsessed with clout and image and brand when you could actually instead get obsessed with solving a fucking problem. I don't know. That's my perspective anyway. So, if you guys want to support the work I'm doing, head over to the Substack. That is Karlyn, KARLYN.substack.com. We are doing a summer membership drive, okay? It's a summer membership drive. I need to get the numbers on my Substack up because I am trying to scale what I am doing. I am no longer dicking around with this on the internet. It's been a long time I've been figuring this stuff out, but I have decided it's time to scale up what we're doing. I want more people in the community. I want more people watching this content. In order to do that, I need more members on my Substack because it's just the way of the world, guys. Money makes it easier to scale. And so All the work I do, almost all the work I do is put out there freely for everyone. When you're supporting my work for $8 a month, $80 a year, you are supporting my ability to put this work free out for everyone. I want to get 400 new paying members of my Substack by the end of the summer. We've got May, June, July, and August to do it. That's about 100 new subscribers a month. I think this is pretty reasonable. I'm going to be putting out a lot of new content. I'm going to be doing free webinars and educational sessions. We're going to be doing book clubs. I'm going to be doing almost daily live streams over on Substack, talking to you guys, giving you stuff to share, answering your questions, stuff like that. If you can't afford to financially support my work, then you can share my work. You can get the content out there. You can share the webinars, share the books, share the information, share the articles. I will tell you what to say. I will tell you what to do, but I need you guys to kind of be the boots on the ground, because if the conservative establishment is not going to share this content, then we need to do it. And it is very, very clear to me that no matter what we say, no matter what we do, no matter how much primary source video we have, the conservative establishment is not going to share this content because it does not follow their political narrative. And that's just reality. So if we want this content out there and we want people to see it, we need to do it ourselves. No one is coming to save you. We need to save ourselves. I will show up for you when you show up for me. It's not just about me being the person on the video. It's about all of us working together to get this information in front of more people. And if we get the information in front of more people, we get more people to come to the streams. If we get more people to come to the streams, we get more people on the Substack. And that's where we get the people that I need to join up as a member for $8 a month, $80 a year, to fund the work I'm doing, to keep this independent, to make sure I never have to go to big donors to take that big check in exchange for following a political narrative. You guys allow me the freedom to do this, and I really, really appreciate it. So sign up on the Substack and support the work I'm doing. Also, this isn't even our last spy stream this week. We have so many spy streams coming up. Spy stream is when we go inside a live leftist training and we film it. We tried to do one earlier today. They never showed up. I see you, Princeton. Princeton stood us up for a live stream earlier. We were there. We were ready to go. And then Princeton never showed up. That's okay. That's okay. Because we've got another one tomorrow. The next spy stream is tomorrow at 6:30 p.m. I'm not going to tell you where it is. Ivy League school. I'm not going to tell you where it is. I'm not going to tell you what it is. Queers for Palestine. I'm not going to say that. Got to keep it under wraps what it is. But if you want to join us for Spy Stream, if you want the full Spy Stream schedule, head over to Decode the Left. This is my new website where we are logging all of the activities and creating usable resources for the world. Head over to decodetheleft.com. Go to the events calendar up at the top. And here is where you're going to find the full schedule of events coming up. We have a multi-day infiltration of an insane event that is going to be happening on Thursday and Friday. It says it starts tomorrow, but it's really Thursday and Friday that it's going to be happening. Maybe even a little bit into Saturday and Sunday, because there's a lot of presentations from this event that we need to watch. Tomorrow at 6:30, we are watching leftists lecturing about Palestine and queer liberation. So literally Queers for Palestine at a major university. Next week on the 30th, we are going into another major university, and we're going to be listening to a lecture about trans activism. Then on May 1st, I have a webinar coming up about my report, The Campus Insurrection. You can find that report over on the Substack. That is a free webinar to guide people through the report and answer their questions. On Friday, next Friday, I have a Zoom link for a webinar about pushing radical ideology in K through 12 public schools. So that's going to be really great. We got a couple webinars coming up where I'm doing some introductory webinars about what people need to know about the left for people who are new to my work. On May 9th, we have another spy stream where we're going to be going inside a day-long event about gender and sexuality at another major university. So we got a ton of stuff coming up, guys. We got a ton of stuff coming up. And so this is the very best time to become a supporter over on my Substack, because the only people who get invited to Spy Stream are people supporting on my Substack, my locals, my Patreon, my YouTube channel members. So if you're a YouTube channel member, you're good to go. My Twitter subscribers, and you guys get to come infiltrate events with me. And there's so many more coming up. We're going to have a busy couple of weeks, guys. We're going to create a lot of content. No one else on the internet reports on these events. Most people on the internet don't even know about these events, but I'll bring them to you. And in return, I ask for you to support my work over on the Substack, Karlyn, Karlyn.substack.com. Link in the description below. and you guys keep me in business, and I really appreciate it. All right, today we're going to be watching, or listening to rather. This morning, the Supreme Court heard arguments for, I think, the ability of parents to opt out of LGBTQ plus books in school. Mahmoud versus Taylor. Let's read. This is on C-SPAN. The Supreme Court heard oral arguments in Mahmoud v. Taylor, a case about a group of Maryland parents suing the Montgomery County School Board over the right to opt their children out of learning from LGBTQ-themed storybooks in elementary language arts instruction. Oh, so queer books in elementary school. Okay. The parents argued the books violated the First Amendment due to content contrary to their religious beliefs, but the school board countered that the books were intended to teach about diversity and respect and were neutral towards religion. Justices asked the attorneys questions such as what other topics students may opt out of, the difference between exposing and coercing students regarding LGBTQ topics, and hypothetical ethical situations involving students encountering teachers and peers who identify as LGBTQ. So it says the U.S. Court of Appeals of the Fourth Circuit sided with the school board, and this is the appeal of the parents to the Supreme Court. So I thought we would listen to this. We don't have video because the Supreme Court doesn't do video, but we do have audio. And I thought we could listen to this and just see what happened to do our due diligence. Obviously, my solution to this stuff in schools is I would like to ban the teaching of all queer anything. Because queer, as you guys know, is a far left political ideology. Queer has nothing to do with being gay. Queer has nothing to do with being trans. Queer is a far left political ideology that is designed to overthrow capitalism via destabilizing the gender binary and the nuclear family. So I don't care if people are gay or trans or any of that stuff. I do believe in absolute parental rights. And so if parents don't want their kids learning things in schools, first of all, I think the best thing most parents can do is to take their kids out of school entirely, homeschool them. I don't think people should be sending their kids to public school unless there's like an emergency or something like that. I think parents should be homeschooling. But I do believe in absolute parental rights where I don't think it should be taught. Like, I think parents should be able to decide what their kids learn in school. But I just think we should ban queer theory. I don't know. We'll see. So let's dig into it, guys. We are going to have a nice, calm listening session over the Supreme Court. Please mount the like button for me. Please make sure you're subscribed to the channel if you're not already. Let's get this party started.
LGBTQ-themed storybooks in schools. Live coverage here on C-SPAN.
Nowhere else to go, the board pleads for remand on strict scrutiny. But petitioners have been seeking preliminary relief for 2 years already at significant personal expense. One family moved in with grandparents to afford private school. Another is homeschooling at the loss of $25,000 a year in special services the school provided their daughter with Down syndrome. Most have no alternatives. Petitioners deserve complete preliminary relief. In a system where thousands of students are daily opted in and out of the class for multiple reasons, there's no basis for denying opt-outs for religious reasons. The board does not dispute that under its theory, it could compel instruction using pornography, and parents would have no rights. The First Amendment demands more. Parents, not school boards, should have the final say on such religious matters. I welcome the court's questions.
Could you spend a minute or two?
I mean, maybe this is my ignorance, and of course we're going to listen to it, but like, I'm going to turn my mic down a little bit because I think I'm really loud. Maybe this is just my ignorance, but like, is the religious argument the best argument to make here? Like, I mean, I'm a highly spiritualized person. I'm not a Christian. And I would still have a problem if I had kids with them learning from these books in schools. But I wouldn't be able to state a religious objection. Like, is that really the best argument to make? Or should we be making an absolute argument based on parental rights, where any parent can opt any child out of learning stuff that they don't want them to learn in public schools if they tell the school? That would be my preference. This shouldn't be about religion at all.
Explain why the record shows that the children are more than merely exposed to these sorts of things in the storybooks.
Yes, Your Honor. I would start with the books themselves. The books themselves teach, for example, that
No, I
children.
mean, what I'm talking about is not necessarily what the books say, but rather is that are the books just there and no more, or are they actually being taught out of the books?
No, we know that the teachers are required to use the books. When the books were first introduced in August of 2022, the board suggested they be used 5 times before the end of the year. That's in the that's at 273A in the CERT appendix. One of the schools, the Sherwood School in June, for Pride Month said that they were going to read 1 book each day to celebrate Pride Month. The board's own testimony through Superintendent Hazel said that the books must be used as part of the instruction, and that at 642 in the appendix, that discussion will ensue. That was the entire point of withdrawing the opt-outs and removing, even notifying parents. They're not even allowed to know. The board said in that statement, it was so that every student would be taught from the inclusivity storybooks. And also the district court transcript at 63 has counsel's admission that some of the books have to be used and it can be more.
The school board alleges that the opt-out system became unworkable. Is that a factor we should take into account in deciding whether it could be
The
required?
opt-out,
Certainly,
wait,
there could be situations where it could be unworkable.
the opt-out system became unworkable, and therefore the school board is arguing that they don't have to opt anyone out of anything because their own system that they created doesn't work. Maybe try creating another fucking system.
The board never raised that until after this litigation commenced. When they announced the withdrawal, they said it was because every student needed to read the inclusivity books. When they produced documents in response to an open records request, there was no mention of it not being workable. When parents met with the superintendents, this is in the Hisham Garti declaration at JA 44. The reason given there was inclusivity. There was no mention of administrability until the litigation's been filed. And even then, all the board was able to come up with was an argument that in one instance, in one school, there were dozens of students who opted out, where if the average school size in Montgomery County is 700 students across at least a dozen classrooms, you're talking maybe 1 student per classroom. That hardly compares with the 1 in 8 students who are opted out for individual education programs. 15% of students in Montgomery County who are taking English for speakers of a second language. The board's own opt-outs that are required from the same instruction required by state law to be opted out when the same books are read in health class.
Counsel, that wasn't the basis of the circuit, of the district court or the circuit court's denial of preliminary injunction. They never reached the issue of whether or not there was disruption or what the motive was for taking away the opt-out. What they decided was that there wasn't coercion here, that it was mere exposure. I understood from the record that all that was required is that the books be put on the bookshelf. If that's all that's required, is that coercion?
Well, that's not what's required here. We know it's
Please
undisputed.
answer my question.
If all that's required is exposure, our clients are not contesting that would be, are not saying that would be a burden.
All right, then let's go to the second step. Let's say there's compulsion to read the book out loud. Is merely being exposed to the reading of the book out loud coercion?
Well, even the board admits that the exposure could be a burden. And for example, they say at 25 note 7 of their brief that if they were exposed to pictures of Muhammad, that would be a burden that they would allow an opt-out for. And certainly whether there's a burden.
Let's go back. Is it generally that the mere exposure, haven't we made very clear that the mere exposure to things that you object to is not coercion?
It would really depend on the individual religious beliefs. Here, for example, our Catholic clients.
So what you're saying is that the exposure of children to the fact that 2 people are getting married is coercion? That 2 people of the same sex are getting married is coercion?
So our clients have not raised that objection. I suppose someone could raise that. But
let's talk about what in the portrayals, so that the mere reading or looking at the pictures, like looking at an image of Muhammad, would be coercion. because I'm looking at the books, I've looked through all of them. They have two men, little Bobby's wedding, where they're getting married. One is black and one is white in this rendition of the book. I had one with mice. The two male mice looked identical to me. Is looking at two men getting married, is that the religious objection?
Again, it would depend on the individual beliefs of the clients. For example, many parents would object to their child being exposed to something like pornography or extreme violence. It would vary.
We're not going there.
So, Mr. Baxter, I'm sorry.
I'm sorry, let me just finish this.
Sure.
One. So just answer my question. Is looking at the pictures, is there any affidavit from any parent that merely looking at people getting married, holding hands, none of them are even kissing in any of these books. The most they're doing is holding hands. That mere exposure to that is coercion.
Our parents would object to that. They follow.
All right, now, so let's move to what I think your objection is. I think your objection is to the student guidance, correct?
Our objections would be even to reading books that violate our clients' religious beliefs. They've been, their faith teaches, for example, they shouldn't be exposed to information about sex during their years of innocence without being accompanied by moral principles. And here we have both books that violate their moral principles and instruction that tells them that, for example, they can pick their pronouns based on the way they feel, not even just for based on their gender, but how they feel from moment to moment.
So, Mr. Baxter,
Before we move away from the book that Justice Sotomayor was referring to, Uncle Bobby's Wedding, I've read that book as well as a lot of these other books. Do you think it's fair to say that all that is done in Uncle Bobby's Wedding is to expose children to the fact that there are men who marry other men?
No, Your Honor, and this court in Obergefell promised that parents would be able to continue to teach what this court called decent and honorable beliefs, that same-sex marriage is immoral according to their beliefs. And it's a far stretch from that for schools to compel students to attend. Parents are paying taxes, they have to pay at threat of criminal fines or penalties or the expense of private school. And then to have teachers telling them things that are directly contrary to their
the book has a clear message. And a lot of people think it's a good message, and maybe it is a good message, but it's a message that a lot of people who hold on to traditional religious beliefs don't agree with. I don't think anybody can read that and say, well, this is just telling children that there are occasions when men marry other men. Uncle Bobby gets married to his boyfriend, Jamie, and everybody's happy, and everything is, it portrays this, everyone accepts this, except for the little girl, Chloe, who has reservations about it. But her mother corrects her. No, you shouldn't have any reservations about this. As I said, it has a clear moral message.
Wait a minute, the reservation is
Can I finish, please? It has a clear moral message, and it may be a good message. It's just a message that a lot of religious people disagree with.
And when you add to that, Your Honor, instruction, if a student disagrees, teachers are supposed to say things like, well, I have friends in that situation. Do you think it's really fair for you to agree? Or to suggest that it's hurtful for students who disagree.
Mr. Baxter, I guess I'm interested in what the nature of the rule you're asking for is. I mean, when you started, it was about, matters pertaining to sex. But as you've answered some of these questions, you've basically said, well, my clients have religious principles that conflict with what is being taught. And does it go that far? In other words, does it matter what the subject matter is? Does it matter what the age of the child is? Does it matter what the nature of the instruction is? If so, how does it matter? Or in the end, is what you're saying, when a religious person confronts anything in a classroom that conflicts with her religious beliefs or her parents, that the parent can then demand an opt-out?
It's really the latter, Your Honor, and that's exactly what Montgomery County allowed in its own religious diversity guidelines. Anything that violated a student's or imposed a substantial burden in their language on a student's religious or parents' religious beliefs, they had the right to opt out.
So this is a rule that applies as well to a 16-year-old in biology class saying, the parents say, I don't want my child to be there for the classes on evolution or on other biological matters which conflict with my religion. It would apply just as well to that.
We know that those don't happen very often because
But it would if there were.
Certainly, and there are laws, for example, in states that allow students to opt out of dissection because they don't want to participate in that. And there are schools across the country, Hawaii, which has a school district about the same size as Montgomery County.
And if that's a pretty broad rule. If that's let me ask what the next step of that is. Suppose there are things that, students opt out of. And then, the parents think it's just not really fair that my kid has to leave the classroom or has to put on, headphones or, has to otherwise be made to feel isolated. So the next challenge is really the class can't do this either. What would your position be on that?
Well, no student, Your Honor, has the right to tell the school what to teach or to tell other students what they have to learn. You would clearly run into problems in that situation.
But to the extent that this is a rule about people being able to access public education in a sort of equal manner, the parent might say, my child is not being able to access education in that equal manner because, he's made to leave the classroom or he's made to do something else that isolates him from the class. I mean, certainly that's an argument that we've often heard with respect to prayer and that people have accepted with respect to prayer, that it's kind of like not a sufficient answer to just say, don't worry, the prayer can go on, you don't have to be part of it. So I'm just wondering whether that's the next step here.
No, Your Honor, I don't think so because, of course, under the Establishment Clause, there are different rules, but under the Free Exercise Clause, we think that on strict scrutiny, those parents would always lose if they're trying to direct the school what to teach or tell other students what they must teach.
Okay, but you are suggesting, okay, so that's a straightforward answer. I appreciate that. But just to go back, and this was also a straightforward answer, which I appreciate, but in terms of opt-out, you're basically saying, opt out for anything. It's really the parents that get to decide, assuming that their beliefs are sincere, right? It's really the parent that gets to decide.
Yes.
Doesn't matter the kid's age, doesn't matter
Yes,
sex,
it's the parent
not
that gets
sex.
to decide. Yes.
Doesn't really matter this whole idea, I suppose, of pressure or coercion.
Yes.
If like just looking at a book would be in conflict with religious principles, that would be enough.
It's up to parents.
Just to be clear, under Yoder, the court left open what would happen if there were kids who objected. But we know that these things, schools around the country already have these very broad opt-out policies across the curriculum. In Hawaii for anything controversial, in Arizona for anything that parents deem harmful. And we just don't find these kinds of cases or these kinds of burdens where parents are bringing extreme examples. Parents with kids really don't have a lot of time to be suing the school board, and they're looking for a reasonable compromise.
I have a whole list of cases where parents have objected to biographical, I'm quoting, biographical material about women who have been recognized for achievements outside of their home, because some people believe women should not work. So too, parents have objected to teachers reading books featuring divorce, interfaith marriage, or in modest stress. Forget about the evolution, because that's come too. You've just said, are these all coercive?
Well, again, it's whatever coercive means, could create a burden. This court has defined burden very simply, that if someone is...
Hang on. So this is where conservatives start to lose me, if I'm honest, because listen, I do believe in absolute parental rights. However, just because you can doesn't mean you should. And it's kind of one of those things where, like, if you cry wolf over and over and over and over and over again, at some point people aren't going to take you seriously. So if you go into and you say, I don't want my kids learning about divorce. Really? Okay. I don't want my kids learning that women work outside the workplace. Okay. Really? I don't want my kids learning that some women don't change their last names when they get married. I don't want my kids learning that there are people that are not Christian in the world. And at some point it's like, you're actually the one being unreasonable here. I'm sorry. Like it reaches the point where you're like, you're the one imposing your religious beliefs on like everyone else. And this is a little nuts. And so then when you come and you say, I don't want my kids learning about the gay books in school, it's like you pile it on top of each other. And at some point someone's like, shut up, bro. Like you hate everything. You're objecting to everything. And so again, if you really have an objection over all of these things, then you need to homeschool your children. Homeschooling is your best option, because like when it comes to like there actually being a problem, because I'm sorry, like it's not a problem to teach people that some people get divorced. That's just a reality of life. But when there comes to be an actual problem, like kids learning about anal sex and butt plugs in the 3rd grade, okay, that's an actual fucking problem. And when you've just delivered them a laundry list of fake problems before that, it makes them less inclined to tackle the actual problems. So this is where conservatives go off the rails, and they think like, they're like, I can do anything. I can do whatever I want. And they get really fucking pompous about it. And it's just like, shut up.
Trying to exercise a sincere religious belief, and the government is prohibiting or inhibiting their ability to exercise that.
To say if someone's prohibiting just looking at something that they object to, that's burdening their religion.
Again, we don't see these cases arise in reality.
For reality's sake, you see interfaith couples all the time walking around.
This is correct.
Interracial couples walking around. You see women on this court in positions of work outside the home.
And no one here is raising a burden in that situation. We're far beyond that where our indoctrination.
But there are cases to that effect in schools.
And those cases,
so tell me where you're going to draw the line, other than saying that if anyone objects to a book, well, you want more than that, because the request here is to instruct the school to tell you its curricula, to guess at what you might find offensive, and then let you opt out. Because that's the injunction you're asking for, isn't it? You're asking for the ability for schools to provide you with the information about what's being taught, and if you object to it on religious grounds, to opt out.
Your Honor, I see my light is on. May I answer the question?
You may, yes.
Your Honor, even under Yoder, without Yoder, under a Smith regime, in here, those things would trigger strict scrutiny. If you're in a regime where there's direct discrimination like we have here, we have students who are being told that they can opt out for certain religious reasons, but not other religious reasons, and that's always going to get you to strict scrutiny.
Thank you, counsel. As far as simply looking at something, looking at the image of Muhammad is a serious matter for someone who follows that faith, right?
That's correct, Your Honor. And Barnett already helps provide some guidance on this, that forcing people to do things that directly violate their faith violates the free exercise clause.
I don't know how often it comes up in the schools, but our religion clause jurisprudence does have the element of sincerity.
That's correct. There has to be a religious belief. It can't be just something that you disagree with for political or philosophical reasons. It must be sincere. There's also a substantiality requirement that depends on the objective pressure that the government's putting on you. All of those things provide a significant screen. And just we know from history, from common sense and looking at what's happening in schools that have these broad opt-out policies, like Montgomery County itself had prior to this lawsuit. Anything that violated your beliefs, you could opt out. And we didn't see these kinds of, and when they have come up, courts have dealt with them in reasonable ways.
Thank you, counsel. Justice Thomas.
I think you mentioned Yoder a couple of times. Would you spend a minute on how Yoder would role it would play in our analysis, or should play?
Thank you, Your Honor. Yoder looked to, in significant part, at the unique coercive environment of the public schools. It referred to the hydraulic insistence on conformity that you find in schools and removing children from their parents for 8 hours a day. Here we have a situation that's even more egregious than in Yoder, where you have children of an extremely young age being indoctrinated in a topic that's known to be sensitive. Every school in the country allows opt-outs since sex ed has been introduced. Unique because of its capacity to evoke curiosity in children, and a curriculum that's designed to disrupt students' either or thinking on sexuality and gender identity. In Yoder, you had incidental encounters with values that were contrary to those of the Amish. And so in many ways, this case is easier than Yoder.
Whose interests are we concerned with here? Is it the interests of the children or is it the interests of the parents?
Thank you, Your Honor. We have named children, but for the preliminary injunction, which again was filed 2 years ago, we have raised the rights of the parents.
As they should.
Justice Alito?
You've made a very broad argument here at times, and it might be good, it might not be good, but let's focus on what's actually at issue in this particular case. What are the ages of the children who are involved here?
These books were approved for pre-K, which in Montgomery County can start as early as 3 if they're going to turn 4 that fall.
And it goes up to what?
The books that we've all talked about go through grade 6.
All right, so you're talking about children maybe in the age of 5 to 11 or 4 to 11. Now, would you agree that at a certain age, students are capable of understanding this point, which probably is not a point that can be understood by a 4 or 5-year-old. And that is that my teacher, who was generally telling me that certain things are right and that certain things are wrong, isn't necessarily going to be correct on everything. It is possible for me to disagree with him or her on certain subjects. Would you agree that there comes a point when a student is able to make that distinction?
Not
That's
that
right. And many
young.
of our clients' objections would be diminished as their children got older. But here we're in a situation where Montgomery County's own principals objected that these books were inappropriate for the age, that they were dismissive of religion and shaming toward children who disagree. The board itself withdrew 2 of the books for what it said were content concerns because it finally agreed that what parents and its own principals were saying was accurate.
Yeah, and one final factor that may distinguish this particular case from some of the others that you have been asked to express a view about, and you did touch on this, is the fact that it concerns sex and gender, and that the Maryland legislature itself has recognized these subjects raise special concerns and has provided for an opt-out from the health classes where these matters are discussed.
Wait.
That's right. And currently in Montgomery County, you can opt out from the very same
Are
instruction during health class.
Are,
but then you're
are
required
you
to
serious? Are you serious? In this school district, they allow the parents to opt out of these subjects from health class, but they don't allow them to opt out of it from English class? This is why it's important for conservatives to understand that these subjects are literally taught in every class your students take. It's not just in some classes. It's literally in all classes. But maybe they do understand that, and that's the purpose of this. But that's crazy.
stay during story time.
Thank you.
Justice Sotomayor?
Counsel.
Well,
couple of
Alito's
questions to
typically on, like,
clarify
obviously
things.
on their side.
Uncle Bob's Wedding, the child character, wasn't objecting to same-sex marriage. She was objecting to the fact that marriage would take her uncle away from spending more time with her, correct?
Again, it would be, courts would be engaged in religious discrimination.
I'm asking you
to
to answer my question. It wasn't that she was objecting to gay marriage, qua gay marriage, period. She was objecting to having her uncle's time taken.
Why does that matter?
I'm not sure that's correct, Your Honor. I think for a child of that age, it's hard to express what their actual concerns are.
Well, when the character says he'll have less time for me, it seems self-evident, isn't it?
Your Honor, again, Montgomery County's own principles.
All right, now let's go back to this question of age, okay? And what teachers are saying or not saying. Do you want a special rule for children between kindergarten and 6th grade?
No.
Well, if the court wanted to go there, that certainly would make common sense. Parents everywhere know that children are especially vulnerable.
Oh my God. Oh my God. What about parental rights are absolute? Does this guy not understand? Do you want a special set of parental rights for children up to 6th grade? Do children up to, are we okay with parental rights being completely ignored after 6th grade? I'm not okay with it. If they're still considered to be a child until they're 18, then parental rights should be absolute until they're 18. If parents are still responsible for taking care of their kids and doing all the things that parents do until they're 18, then parental rights are absolute until they're 18. There's no special set of parental rights for kids that are of a certain age.
Mere age is coercion. Exposure is mere coercion of a certain age.
Well, this court has frequently recognized that, for example, children lack the maturity to make decisions, to discern sometimes between truth and error, to weigh what their parents are saying versus what their teachers are saying.
So if some of this objection, you said you don't have an objection to showing an interracial marriage, you don't have an objection to merely gay couples shown to marrying, as long as you don't have approval of that? Is that what you would object to?
Well, Your Honor, again, it would depend on the individual's beliefs. And this court has already held, for example, in Bob
So
Jones,
if none
that
of
there's
all of
burden.
the parents, many of the affidavits that the parents put here said they don't mind teaching respect and kindness towards people who are different. The objections appear to be with some of the teacher instructions, the ones having to do with altering the mindset of children, or the ones talking about gender being a guess at birth. Those were the things that I saw the parents objecting to.
The parents object to the books and to the instructions. There's no question that together, and even
We can
separately,
look
the
at the
books go to
records. We
indoctrination
can
more
look
than
to
exposure.
the record for that, correct?
I'm sorry?
We can look to the record.
That's correct.
Thank you.
Justice Kagan?
I want to take you back to some of the questions that Justice Alito was asking, because I too was struck by these are, young kids, picture books, and on matters concerning sexuality. I suspect there are a lot of non-religious parents who weren't all that thrilled about this, and then you add in religion, and that's even more serious. But I guess I'm searching for what in your legal arguments would allow us to draw lines in this area, and I'm kind of not finding it from what you were saying to me in our earlier, or what you said to Justice Alito, because when Justice Alito said, "How about that 17-year-old?" you said, "Well, many parents' objections would decrease," but that still indicates that if a parent said, "No, even with respect to that 17-year-old, I still care about this. I want an opt-out." You're not giving anything that would allow lines to be drawn. And I'm just curious if you think lines can be drawn and where they would be drawn and on the basis of what First Amendment doctrine they would be drawn.
We think there are lines that can be drawn. They're the same lines that this court has drawn in every other free exercise case. And the burden a plaintiff has to show that its beliefs are religious, that they are sincere. There has to be a substantial infringement or burden or pressure. And then on the strict scrutiny side, there are also.
But I'm hearing you saying that the burden that you're saying, and of course we're just assuming that all these people have sincere religious beliefs. Let's just assume that. But what I'm hearing you saying is the burden is basically up to the parent to decide, this conflicts with my religious beliefs, I want an opt-out. Is that correct?
Yes.
Yes, and on the Sherbert side, under strict scrutiny, they would have to first show that there is a law that's not neutral or generally applicable, so there's a limit there. And on the Yoder side, if this court didn't want to go all the way to address the issues that aren't present in this case, it could rely on the uniquely coercive environment of the schools. And now putting those kinds of issues on the burden side.
Still, it's like just pretty. I mean, I'm really searching for something, and I know that you realize that, and you're still not giving me anything other than if it's in a school and a sincere religious parent has an objection. That objection is always going to result in an opt-out.
Yes.
No matter what the instruction is like, no matter what the materials are, no matter how old the kids
Kate, and
are.
I agree.
And that's the rule that schools everywhere in the country are working under right now. by their own choice. That was Montgomery County's own rule before this lawsuit came in. And there were never these kinds of problems until it really introduced a curriculum that was clearly indoctrinating students in things that the principal said was introducing things as fact that aren't
Yeah, but
fact.
once we articulate a rule like that, you're going to have a lot of parents, it seems to me. I don't think you can say just because it hasn't happened. Once we say something like what you're asking us to say, it'll be like, opt-outs for everyone.
Yes. Yes, Elena. Yes, that's exactly right. Once you affirm parental rights, parents will start acting like they actually have a choice in this matter because they should. Because they should. Parental rights are absolute. The will of the state, which, by the way, we're all paying for these schools. I don't have children and I pay property taxes, 75% of which go to fund the public schools that I will never ever use because I don't have children. Parental rights are absolute. If parents feel that the state should not be usurping what the parents want, if the parents have a sincere objection about anything.
The government always wants to put these things on the burden side instead of the strict scrutiny side. We heard these arguments in Hobby Lobby where there was a lot of concerns about what would happen in Ocentra, what would happen with drugs. And in reality, we didn't see those kinds of floods happen up. And when they have, the courts have managed to deal with them without any significant difficulty.
Thank you.
Justice Gorsuch?
You've spoken a little bit about Yoder today. I'd like you to hear your thoughts about the Smith side of the argument. And the Fourth Circuit suggestion, I think it's a fair reading of the footnote, but maybe not. I'd like both sides to think about this. Whether if you fail Smith's neutral and generally applicable rule, whether a plaintiff still has to show a substantial burden or whether you go straight to strict scrutiny.
I think you would just have to go, I think at that point, if you've shown lack of neutrality and general applicability, you would still have to have an injury, maybe something.
For constitutional Article 3 purposes.
Exactly.
But do you have to show a substantial burden, or is that law that is not neutral, that discriminates against religion? Does that go straight to scrutiny?
I think the standing injury would be sufficient. And here's an example why. If you look at the board's, for example, revised diversity guidelines, they try to draw a line between curricular activities and extracurricular activities. Yet they also say, and this is at 674 of the appendix, that you can opt out of choir or band if you object to the religious songs. Is that curricular or extracurricular? They also say on the extracurricular side, you can opt out from things like Valentine's Day if you don't like the religious overtones of that holiday. But when Sherwood Elementary School announced that it was going to read one book of the inclusivity books every day in June for the month of June to celebrate Pride Month, you couldn't opt out. So there's this discrimination where you get some religious reasons get opted out, some don't. There's these labels about curricular, extracurricular, English and language arts versus health. But in the end, it's the same thing. And some students are getting opt-outs and some aren't. That discrimination alone is a burden that gets us to strict scrutiny.
Thanks, Annie. Appreciate it.
Justice Kavanaugh?
A few questions. What's your understanding of how the surrounding counties are dealing with this? Frederick County, Howard County, Prince George's County, Anne Arundel County, and the like.
Yeah, Carroll County, for example, has taken the position that it will teach inclusivity without indoctrinating students. And so it's not introducing this ideology, extreme ideology about gender, whether your body says anything about your gender, whether doctors guessed at your sex, whether your pronouns change day to day based on the weather or not, whether you should petition for, unisex bathrooms. It's teaching inclusivity without that indoctrination. And our clients agree. Every student deserves to be respected and loved, and nobody disagrees with that. But you don't do that by forcing others. In fact, religion is another one of the categories in the equity regulation.
Listen. This is another thing that's going to get you guys into trouble. You said earlier, you pretended to understand this earlier, but I'm going to make this really fucking clear. If you guys object to teaching people in school that everyone is worthy of basic respect and dignity, then you are going to lose. If you run around saying inclusivity is an ideology, we don't want to teach our kids to be inclusive because of reasons X, Y, B, you're going to lose. No one's going to be on board with that. If there is a way to teach kids, hey, you know what? Be nice to people. Don't bully people. Don't be mean to people. Like, treat people well. Offer everyone basic respect and courtesy as a human being. If you guys object to that because you're like inclusivity, you are going to lose and the left is going to win, and it will be your own damn fault because you dug in your heels over something stupid. Basic respect and dignity is a good thing. Teaching kids to treat people okay and not to be bullies is actually a good thing. I know conservatives love to be bullies and they love to be cruel on the internet for no good fucking reason, and they turn everyone off by being bullies and being cruel on the internet for no good fucking reason. But like, that is actually a reasonable request.
Is required to be respected. The principals, when they first responded to this curriculum, their concern was for the religious students, that they were going to be dismissed and shamed for their beliefs.
And I think you just said this, but you're not seeking to prohibit instruction in the classroom. You're just seeking not to be forced to participate in that instruction.
That's correct.
The term coercive, I think, has been used in some of the colloquy, but the right term is burden. Isn't that correct?
That's correct, Your Honor. And if you think about their example of saying, like, the Fourth Circuit said that, the students were never asked to change their religious beliefs. Is it enough if you just ask them, will you change your religious beliefs?
No.
Does there have to be something more?
No, Groiper. No. And this is why you guys piss everyone off. Because you guys, and by you guys, I mean Groipers, will default to being cruel assholes to people instead of just treating people well. Do you guys know how much faster I probably would have come around to Nick Fuentes had it not been for Groipers being assholes in my replies? Do you guys understand that the reason I'm not promoting Nick's stuff right now is because I had to deal with an overwhelming amount of Groipers trying to tell me who I could retweet on Twitter when I wasn't saying anything about Nick? Don't throw this bullshit at me. If you want respect for yourself and you want respect for your heroes like Nick Fuentes, then you need to offer respect for other people. If you want respect for your religion, then you need to offer respect for other people's religious beliefs. If you want people to stick up for you, then you need to stop being assholes and demanding to control what they say and do, and then screaming like a bunch of unhinged fucking hooligans when you don't get your way. Respect should be basic human respect and courtesy. And by the way, that's exactly what Nick does. Nick himself treats people with basic respect and courtesy. I've seen it time and time again. Nick even treats people he doesn't personally like with basic respect and courtesy. And then they come and attack him. And then once they attack him, bets are off. I'm not saying to you that you should treat people with basic respect and courtesy if they're attacking you, but you start with basic respect and courtesy. And then if someone attacks you, game fucking on. But you guys don't do that. You guys start with cruelty and bullying and bullshit, and then you wonder why no one likes you. It's because you're the ones starting it most of the time. Because of this attitude, you have to earn our respect. No, we fucking don't. No, we don't. I stood up for Nick for over a fucking year, for almost 2 fucking years, all the fucking time. And do you know what happened in that time? I constantly had Groipers shitting on me. Constantly. So don't tell me that there's any way to earn your guys' respect when there's obviously no path to it. And this is why people don't like you, honestly. And by the way, Nick even tells you guys this on his show. I've seen the clips of it. Nick tells you guys, stop being dicks to people who support me, and you still don't fucking listen.
Is really not a workable standard. And schools should not be treated differently than any other government entity as far as what their obligation is. And it somewhat flips the Bill of Rights on its head if we're worried more about extreme examples that don't happen, to protect the government from the parents as opposed to protecting the parents' fundamental rights to direct the religious upbringing of their children.
And then in terms of sincerity, in other words, if you're lying about your religious belief, that can be inquired into, but not the legitimacy, the reasonableness, the acceptability, the consistency, none of that. The court has no business questioning any of that about someone's religious beliefs, as I understand our case law.
That's right, Your Honor. In this case, again, the fact that the board has admitted that they would give opt-outs to Muslims who object to their children viewing an image of the Prophet Muhammad, but not our Muslim clients who object to their students reading these books, shows that that kind of analysis would entangle courts in religious questions and invite religious discrimination.
And then I guess I am a bit mystified as a lifelong resident of the county, how it came to this. Can you just tell us what happened when in March of 23, you know, what happened in terms of the objections and how the school board responded, to give us a little bit?
Well, I share your concern. My kids graduated, two of my kids graduated from MoCo and were opted out when they asked on their own accord to opt out of some instruction on sex education. And what happened is, we're not even entirely sure, because for the entire first year, the board promised in multiple places on Fox News and other media that parents would be notified and then they would be opted out. The last notice happened on March 22nd, 2023. The very next day, overnight, with no explanation, the board came out and said, we're changing the rule because we want all students to be instructed on inclusivity. That's at 547 in the appendix. That emphasis on all students have to receive this instruction, nothing about administrability. And then from there on, even then they said, if we've already told you you can opt out, we'll let you do that, but more parents can't ask. And then it wasn't until later in the year when they actually revised their guidelines, which still allow certain religious opt-outs and just not others. So this was clearly targeted at religious parents objecting.
But then complaints were raised, right?
That's right. Hundreds of parents complained. These were mostly, according to the news articles, mostly families from Muslim faith and Ethiopian Orthodox who were objecting when they spoke to the board. The board accused them of using their religious beliefs as another reason to hate, accused a young Muslim girl of
I don't know if you're giving me a compliment or not, because I did watch a couple of seasons of Peaky Blinders, but I don't remember it. I remember liking the show, but I don't remember who is Polly on Peaky Blinders. Cillian Murphy was really hot in that show. I basically just watched that show to look at Cillian Murphy. I'm not even sure I registered any of the other characters. Are you giving me a compliment or are you being mean, offensive, Saint? Just tell me, okay? The aunt, I guess. But was she like, was she one of those, I totally don't remember. I really don't remember. Was she like someone who told them off when they were being stupid? Okay, I'll take that. If the aunt was the sage advice giver that told the guys off when they were being dumb, then I'll take that, I guess.
parroting her parents' dogma, and then accuse the parents of aligning with racist, xenophobes, and white supremacists. And so, again, there's no question in this case that there is a burden, that it was imposed with animosity, and that it's discriminating against our clients because of their religious beliefs.
Thank you. Justice Barrett?
So, counsel, we've talked a lot about burden, and I'd like to get a definition. So Justice Sotomayor's questions, I think, track what the Fourth Circuit said, which is that compulsion is required. That's not your position, that compulsion is too far, right? So can you precisely define for me what it means to have a burden?
Yes, I think there's three main ways this court has reviewed that. Under Yoder, it would be, is there substantial interference with the parents' ability to direct the religious upbringing of their children? We think we've shown that here. Under cases like Sherbert that have continued through to Fulton, it's, are the parents being pressured to abandon or modify their religious beliefs in order to access a public benefit, like public education? And then I think we also have what I think Justice Gorsuch may have been suggesting, just if there's straight up discrimination where some religious students are opted out and others aren't, then that itself would also be a burden. And I think we satisfy any one of those tests.
Okay, I have questions for you about those tests, but I'm going to bracket them to just follow up on the burden question. Substantial interference from Yoder. So would you say you could root it in that because it's rooted in the case? Is it somehow rooted in the definition of prohibit in the First Amendment? Because it seems to me that, the questions that you're getting are about line drawing. I mean, Justice Kagan was making this point. And one place where some of that line drawing might happen is in the definition of burden. So I think the definition of burden is important. And really, that's the main thing that's before us. The question of whether you get an opt-out really goes to the Smith analysis or strict scrutiny under Yoder. We don't even have to decide that, right? We don't have to decide whether you get the opt-out. We just have to decide if the Fourth Circuit accurately defined what a burden is.
I mean, the court doesn't have to. It's true. I think there are multiple reasons why this court should.
I know you want us to, but we don't have to.
Correct.
And really, what we have to do is nail down what it means to burden the right?
That's correct.
Okay. So unreasonable interference, and you would root that primarily in Yoder for that strain of the doctrine.
Correct.
Okay. Now, what kind of a claim are you bringing? Are you bringing a hybrid rights claim for purposes of Yoder? Are you kind of bringing all of them, like a straight up free exercise claim, a Smith claim? I mean, it's a little bit hard to pin down.
Yeah, I think we're bringing all of them. We think in Smith, the court said that Yoder fell outside of its rule. Excuse me. And so we think that that's a separate track. And whatever the court meant by hybrid rights or other rights that were at issue in Yoder, we have those same here. However you define that, this is almost exactly the same situation where parents are concerned about what their children are being taught in the highly coercive environment of the public schools. And here we have even more egregiously curriculum designed. The board said, when you select these books, we want you to select books that will disrupt cisnormativity, disrupt heteronormativity. And so we think that whatever Smith meant by hybrid rights that may have been at issue in Yoder, we meet that definition.
Do we have to embrace that?
By the way, this lawyer has no effing idea that what he just said is queer Marxism. Conservatives have no effing idea that what that lawyer just said is queer Marxism. These are not books about being gay or trans. These are books about being queer.
Hybrid rights theory in order to analyze your claim or your definition of burden for purposes of Yoder? Do we have to say Yoder is about hybrid rights and this is why you satisfy?
I don't think so, Your Honor. This court, as recently as in Espinoza, recognized Yoder as a case being about the free exercise right of parents. The questions presented in Yoder were all about free exercise. And so I don't think that any side statements that were made in Smith have to govern how this court treats that rule here.
Okay, and now let me ask you about the burden in this case. So there's been a lot of talk about exposure. The Fourth Circuit said this is just about exposure. You've pointed out, that in cases like, intersection allies, there's actually in the book, it presents a worldview, right?
And it says, let's disrupt the norms, that book.
Let's disrupt the norms. And many of the books, it's not just pictures, it's actually the text.
So these are basically revolutionary books that are trying to teach kids a revolutionary political ideology. And that revolutionary political ideology, by the way, wants to abolish the Supreme Court. I wonder what would happen if the Supreme Court justices knew that what these books were actually teaching was a radical revolutionary Marxist political ideology to children in elementary school, and that radical revolutionary ideology eventually leads to the abolition of the Supreme Court, the abolition of the White House, the abolition of basically our entire government, the abolition of the U.S. Constitution, because they believe that all of these ideas are grounded in capitalism, and they want to overthrow capitalism, which is why they're teaching kids these ideas in the first place. Wouldn't it be nice if the right understood what they were actually talking about so they can make, maybe a better argument that these books are within an ideology that is designed to overthrow the government, and we're going to show you how it leads to that. Wouldn't that be nice? Well, and this is just it. It's like, even if we showed them the evidence, they wouldn't get it.
It's talking about there are not just two genders, embracing, non-binary and pronouns, et cetera. So that's exposure, though, to those ideas. It's not just exposure to the pictures of, the two men getting married. It's exposure to the ideas.
Correct, Amy Coney Barrett.
But to clarify, what are your clients objecting to? Are they objecting only to exposure, or are they objecting to what they're calling indoctrination?
If by exposure you mean having the books read to them, they do object to that. They're not objecting to the books being on the shelf or available in the library without a teacher requiring them to read it or reading it to them.
So you would not be making the same claim based on your clients' religious beliefs if they were just on the shelves or just in the library?
Correct.
Could another parent bring that claim?
I suppose they could, but then you would, I mean, again, we don't see these kinds of claims happening, but they would almost certainly lose because strict scrutiny would easily be satisfied if every student were allowed to say, I want this book.
Moms for Liberty just gutted in the Supreme Court. Moms for Liberty just took it up the ass in the Supreme Court, and I fucking love it. Let me explain to you what just happened. Amy Coney Barrett was like, so basically this lawyer, and I actually do think this is the correct argument to make. This lawyer is basically saying that we don't care if these books are on the bookshelf. What we care about is a teacher reading them to students as part of a required curriculum in the class. So they're not objecting to the books being in the classroom, like being available for other people. They're not objecting to the books being available in the library. The only thing they're objecting to is requiring students to participate in lessons guided by the teacher, where the teacher is reading the books to the student and they're talking about it. That's actually kind of a reasonable argument to make. They're not saying you can't teach this to everyone. They're saying you can teach it to, you can teach this. You can have the books in the classroom. You can make these books available. We just don't want our kids interacting with them in this. So can you send them into the other room and have them do a worksheet or something like that? Like, that's all they're saying. Now, why Moms for Liberty just got bent over and fucked by this lawyer in the Supreme Court, and I'm living for this, is because Moms for Liberty is the organization that would sue to try to ban those books from being on the bookshelves. Moms for Liberty would actually do that. In fact, Moms for Liberty has been trying to do that all over the country. And so what this lawyer just said is, if any organization or any parents try to sue you just to get these books off the shelves, they're going to lose for reason X, Y, B, and Z. Let's listen to that again, because I love nothing more than when I see Moms for Liberty just blatantly getting nailed in the middle. And also because Tiffany Justice of Moms for Liberty was tweeting about this. She's like, we're in the Supreme Court today. Not Tiffany. You just got bent over and fucked, girl. You just got bent over and fucked in the Supreme Court, Tiffany. How does that feel? Again?
To read it or reading it to them.
So you would not be making the same claim based on your clients' religious beliefs if they were just on the shelves or just in the library?
Correct.
Could another parent bring that claim?
I suppose they could, but then you would, I mean, again, we don't see these kinds of claims happening, but they would almost certainly lose because
they would lose.
Strict scrutiny would easily be satisfied if every student were allowed to say, I want this book or not that book. I mean, no student has the right to tell the school which books to choose or what curriculum to teach or what other students will have to learn. And so we think that those would easily fail.
What was that, conservative lawyer? No student has the right to tell the schools what to teach or what other people can learn. Oh, he did. This conservative lawyer just rammed a nuclear torpedo into the Mills for Liberty and their entire effing argument. Oh, how beautiful. We have to listen to it again. I'm sorry. This is like the best moment of the day. You guys don't know. I have been fighting with Moms for Liberty literally since they started this bullshit in 2021. I have never supported this strategy from Moms for Liberty. I flat out said over and over again, this is going to backfire for reasons X, Y, B, and Z. They blocked us. They smeared us. Tiffany Justice, like, is such a raging cunt to me. Like, it's so unbelievable. And bent over and fucked Tiffany. Nuclear torpedo into Moms for Liberty in the Supreme Court. And it doesn't even matter what the outcome of this case is, because this moment is everything.
See these kinds of claims happening, but they would almost certainly lose because strict scrutiny would easily be satisfied if every student were allowed to say, I want this book or not that book. I mean, no student has the right to tell the school which books to choose or what curriculum to teach or what other students will have to learn. And so we think that those would easily fail under strict scrutiny.
Okay, so it's not about exposure. It's not about books on the shelf. It's not about books in the library. It's about actually reading the books with the text that communicates the ideas that are contrary to your client's sincerely held religious beliefs.
Right. Their beliefs, they follow, for example, the papal exhortation under Familiar Consortio that they shouldn't expose their children during their innocent years to instruction on sex that's disconnected or disassociated from moral principles. And so that's what and the Mahmoud family, they also have an objection to any kind of discussion for young children outside of their family circle, as do many families, as the courts noted.
Okay, and so I want to talk about the public benefit analysis. So the government frames this in terms of public education as a public benefit, and your friends on the other side do too. And I'm just trying to figure out if that's the right way to think about this, because in Maryland, you're compelled to send your children to public schools, and it's a misdemeanor if you don't, and you're fined if you don't. And it's true that the statute gives you an exemption to that compulsion if you choose homeschooling or private school. And what is it, like thorough and comparable instruction. But this isn't like a public benefit like we apply for, rubber tires for our playground, or, we apply for a license to engage in some kind of activity. There's actually a compulsion here. So is public benefit the right way to think about this?
Well, I think if the court does think about it in that context, it's a much more valuable benefit than just getting access to rubber tires or some of the other things this court has found burdened religion. And so, but also I think the coercive element is adequate for this court to reach a conclusion in favor of my client.
Well, which way do you think it fits better? I mean, you're compelled to send your child to public school and pay a fine unless you take advantage of an exemption. So it's just hard for me to see how it's a public benefit in the same way that some of our cases have talked about public benefits. So which model? I mean, I understand you don't want to disclaim public benefit, but which way do you think it fits?
Well, I think certainly the Barnett example is a very good example of where you're actually compelling children to do things that are against their beliefs. And I think that would be that's a very fitting model for this case.
Okay, thank you.
Justice Jackson?
So I guess your colloquy with Justice Barrett makes me wonder whether this case is really the right vehicle to evaluate.
Hey, thanks, Matthew. Appreciate it.
Issues. I mean, how can we say that you meet any definition of the burdens? Justice Barrett went over several different versions of them when we don't even know how these books are actually being used in the classroom. I mean, this
Only
was
there
what
was
I understood
cameras.
the Fourth Circuit's primary holding to be, that the record is threadbare. It contains no information about how any teacher or school employee has actually used any of the books or what any child has been taught in conjunction with their use. And it seems that aspects of your argument are turning on whether the books are just on the shelves or whether students are being taught. And so why wouldn't we wait until we have a record regarding those things before we make any legal pronouncements about what's happening in this case?
Well, two responses, Your Honor. First, this is a preliminary injunction, but if you think about the case, for example, Brown versus, hot, sexy, and safe, is that, and I don't even want to describe what happened in that case, but should that kind of graphic sex simulation with a student and a teacher have to happen before you bring a claim?
But I need you to focus on my question. This is a preliminary injunction. I appreciate that. When you seek a preliminary injunction, you actually have to have a factual record that is the basis for the court to make
I
a
don't like her.
determination
She's
in your
annoying.
favor that some conduct that you're complaining about needs to be enjoined. And what's confusing to me and hard, really hard in this situation is that we have a lot of sincerely held beliefs and concerns and children and principles, and I see all of those things. And so really want to be careful about making the pronouncement that relates to this. I don't understand how we can do it on this record because we can't know. We don't at this moment, based on the record you've provided, know that these books aren't just sitting on the shelves. And you've said that if that's the case, that's not going to be enough.
I disagree, Your Honor. The record is undisputed. And I, again, will refer you to the district court transcript at 63, where counsel
So you're
said
saying the
this.
Fourth Circuit is wrong when it says, quote, we don't have any information about how any teacher or school employee has actually used any of the books.
Hey,
the
thanks,
Court of Appeals
Scott.
did not dispute that some of the
Appreciate
books
you.
have to be used, and we have
Thank you
all
guys
of
for
the
the
I
super
teachers'
chat.
instruction that the board's not
I
disputed.
understand that, but the Fourth Circuit made a ruling that we don't know, quote, what any child has been taught in conjunction with their use. So are you saying that you do have affidavits and information about teachers in the classroom and what they've taught children of different ages about these books?
Yes, we do. All of our clients have, in their declarations, they describe which books were going to be read to their
Were
children.
the
and why
clients
they
in the
asked
classroom?
They were not in the classroom, but they know. And again, we don't have to wait until the injury has happened to get relief. The point of a preliminary injunction is that we can, when the injury is imminent, we can seek relief.
All right,
to
let me
stop it
ask
from
you
happening
another.
before our children's
Let me
innocence is
ask you.
destroyed.
Let me ask you another series of questions because I'm just trying to understand the implications of the rule that you want us to reach on this record where we're not really sure what's going on. Is your argument actually confined to the content?
If I was a lawyer right now arguing this case, I would not be able to keep a straight face. I'm not sure I would be able to like avoid being a bitch because Ketanji Brown Jackson is being such a bitch right now. She's being such a condescending, arrogant, pompous, like leftist bitch. And it's like, lady, I mean, I'd be like, okay, obviously you're not going to be on our side, so I'm not going to pretend that you're being, nice because you're not.
Into the school's curriculum. I mean, I appreciate that you say we're in the public school. This is a uniquely coercive environment. But what if we have a teacher who is gay and has a photo of a wedding on her desk? Is a parent able or could they opt out of having their student be in that classroom?
Well, we think no, because the student, the student may claim a burden, but on the question of the student doesn't have the right to tell a teacher what to say. The teacher has speech rights.
But I guess I don't understand that given your argument. I mean, so, example one, we have a gay teacher in the classroom and they have a wedding photo on their desk and the children are exposed then to the same kinds of picture that you say is in the book that you don't want children to be exposed to. What about the parent, the teacher showing pictures from the wedding, or the teacher goes off to get married and comes back and talks about their spouse? Do we have?
Can I just get like a show of hands in the chat? Actually, one in the chat if you had teachers in school that showed you their wedding pictures. 2 in the chat if you never saw your teacher's wedding pictures in school. 1 in the chat if you had teachers showing you their wedding pictures. 2 in the chat if you never saw a single teacher's wedding picture in school. I'm just curious because I went to rural Vermont public schools growing up. I never saw my teacher's wedding photos. I never even knew what my teacher's spouses looked like. If I happened to see a teacher outside of school, it was a very weird experience. And if I happened to see a teacher with their spouse outside of the school, it was an extra weird experience. And I just there's no reality in which teachers would have ever shown me their wedding photo album. So it looks like we got the Groiper has a 1. So the Groiper saw his teacher's wedding pictures. Well, they're younger. So maybe, and this is why I'm asking, listen, I'm old. Obviously, I'm 29. I'm not a day over 29. But in reality, I graduated from high school in 1999. And so I went, my formative years were in the 80s and the 90s. And so maybe it was just a little bit different back then. Maybe people just didn't bring their wedding photos to work back then. I don't know. Why are they bringing their wedding photos to school?
Doubt provisions for children in that situation?
Again, we think the same rules would apply. And if you were in a system...
The same rules would apply. So this is not just about books. This is about exposure to people of different sexual orientations and the sincerely held objection that children shouldn't be exposed to this.
Again, our clients are not raising those, and we know that these kinds of objections aren't happening. Here, the board is imposing indoctrination on children.
What if a student group puts up "Love is Love" posters around the school?
Oh my God!
Featuring same-sex couples or trans youth. Do parents have to have notice of this.
Maybe
and the
we shouldn't
ability
allow
to
that.
opt their
Maybe
children
we
out
should
of
ban
going into
that.
the parts of the school where
Maybe
these
we shouldn't be
posters
doing that.
are.
Again, we don't think that any child has the right to dictate what the school does or what other students
No, they're not
say
dictating.
on
They just
campus.
want an opt out. They don't want their children walking
We think they
in
would
the
lose on that in that situation.
Why? What about your principle does not also mean that if we have a section of the school with love is love posters and, children who have to go through there, what about your principle says that a religious parent shouldn't be able to say, I don't want my kid walking in that part of the school?
Well, they would lose because the strict scrutiny analysis would favor the board in that situation, because it would be impossible for the board to satisfy every student's needs about what's on the board. Now, if you're in a situation,
I'm sorry, it would be impossible for them to actually implement and opt out in that situation?
That's right. So if the request, for example, is so broad, like it was in Yoder, that the only option is for the students to be removed from the school entirely, that would be then the least restrictive means available. And so under normal strict scrutiny analysis, these things.
Can I give you one more? What about
schools.
a trans student in the classroom? There's a student who's in the class. Must the teacher notify the parents of the student's existence and give them an opt-out to not be in the same classroom with this child?
No, and we've never said that there's an independent right to be noted for schools to anticipate what parents might object to, but when parents know something, there could be a sincere religious burden.
Yes, a parent knows. The child comes home and says, there is a transgender child in my classroom, and I know what you've taught me in terms of religious teachings. I object to that. Parent knows. Can a parent insist that the school allow the child to sit out?
Again, we think the parents would lose in that context.
All right, let me ask you one other set of questions about coercion, because Justice Kavanaugh points out that the test is burden. I had understood that the way in which this court analyzed burden in these.
This is a really good point. We are talking about elementary school students. And Ketanji Brown Jackson is like, what if there are trans elementary school students in your class? It's like, maybe there just shouldn't be. Maybe there just shouldn't be. Maybe there shouldn't be trans students in elementary school. Maybe we should not be doing that. Maybe that's a really bad fucking idea in elementary school. It's like a bad idea in general. And again, like, I don't care if people are trans, like, but if you're telling someone that they're trans when they're in elementary school, I don't think that is a good idea.
Kinds of cases is to look to coercion. So there really aren't a separate thing. And I guess what I'm really puzzling over is that it seems to me that coercion in this context is actually operating at two different levels, and that we have to kind of really focus on that in order to understand what's happening. One is to the students in the classroom, the coercion of being forced to be exposed to these kinds of materials or these kinds of things, or can they opt out? But I think there's another coercion, and you've touched on it a little bit, and that is assuming that there's no opt-out in this environment. Are students being coerced into being in that school at all? And I think those two different ways are really, really important. I mean, as I read our cases, we could have set up a constitutional framework in which all students are required to attend public school. They have to go to public school. And I think in that situation, you would have a pretty strong argument that it burdens a parent's religious exercise if the public school teaches children things that contradict the parent's religious beliefs. Here I am, I'm a religious parent, I have to put my kid in this school, and when my kid goes there, he's learning all sorts of things that I'm saying against my religious belief. I get that. But what do we do about the world that we're actually in, which is where Pierce says that the parent can choose to put their kid elsewhere, that you don't have to send your kid to public school. In that situation, I guess I'm struggling to see how it burdens a parent's religious exercise if the school teaches something that the parent disagrees with. You have a choice. You don't have to send your kid to that school. You can put them in another situation. You can homeschool them. How is it a burden on the parent if they have the option to send their kids elsewhere?
The world we live in this case is that most parents don't have that option. They have 2 working parents. They
Yes,
can't
as a
afford to
matter of
send a private
practicality,
school,
absolutely.
and that's the reality for our parents.
I understand, but in so many other constitutional doctrines, we don't focus on whether people actually can afford to protect their rights.
Well, here
in
they're
so many
forced
other
to, they're forced to
doctrines.
pay for the public
No, I
schooling.
understand, but usually we set aside and we say, but you still have the right to get an attorney in a civil case, even if you can't afford it, right? So we don't focus on whether or not they
Guys, do you know what would fix this entire problem? Why don't we just abolish all public schooling? Why don't we just do that? That would fix, if we just got rid of public schooling in general, we wouldn't even have this problem at all. Parents would have to figure it out. There'd be homeschooling options. There'd be private schooling options. They would have all this extra money that they're not paying, and property taxes and all this ridiculous stuff with the schools. They can use that to set up their own like homeschooling pods where they can teach whatever the flip they want. Charter schooling would private schooling would probably proliferate, which means the cost would come down. It'd be great. Let's just abolish it. It would fix everything.
can actually do it, they have an option. And what I guess I'm worried about is a world in which when there is an option to send your kids somewhere else, it seems to me that these parents would be dictating what this school does in the way that you say our cases say they can't do. Right.
In Carson versus Fulton, this court never required coercion. The parents were already paying tuition to go to the school. In all those cases, Lukumi, the schools didn't really need tires. They weren't being coerced to do anything. This court has always sent Sherbert, Adele Sherbert, Thomas. They weren't being coerced to do anything. They just were being pressured to violate their religious beliefs in order to access the benefit that's much less valuable than education.
Thank you, counsel. Ms. Harris?
Mr. Chief Justice, and may it please the court. When the government forces people to choose between violating sincerely held religious beliefs or forgoing a public benefit, that burdens religious exercise. In Fulton, offering foster care contracts only to groups that would certify same-sex couples burden groups that believe marriage is only between a man and a woman. In Sherbert, offering unemployment benefits only to people willing to work Saturdays burden those for whom Saturday is a Sabbath. Here, Montgomery County offers a free public education to parents only if their children use books featuring same-sex relationships and transgender issues. That burdens parents of multiple faiths whose religious duty is to shield their young children from such content. Public schools routinely accommodate those burdens with opt-outs, which respect families of many faiths and backgrounds. Several states allow opt-outs from any learning material on religious grounds. Montgomery County allows many other opt-outs, just not here. I welcome the court's questions.
Ms. Harris, is there any daylight between your argument and petitioner's argument?
Only as a matter of emphasis. I think they're making a more varied range of arguments with respect to sort of parental rights as potentially a separate strain. Here, I think we all agree that certainly one framework, and the framework we're advocating for, is to view this as putting a price on a public benefit of public education at the expense of forgoing your religious beliefs. Petitioners agree with that. And we agree with petitioners that the fact that there is a long history of parents controlling the religious upbringing of their children in the school context is, if anything, just illustrates exactly why there's an obvious burden here.
What role does Yoder play in your analysis?
Yoder is a textbook example of parents being forced to choose between paying a price, which is
breaking news. Republican lawmakers from Tennessee and Michigan push for the Supreme Court to overturn decision legalizing same-sex marriage. What retards. What absolute. Let's just give the queer Marxists everything that they want. Let's just give the radical left every single thing that they want. And let's like it wasn't enough that they gave them the abortion gift that the left is going to raise money on forever and ever and ever and ever and ever and ever. It wasn't enough that you gave them the overturning of abortion, which is going to lead to more abortion, not less abortion, which is going to lead to them smuggling abortion pills into states where it's banned, which they were already planning on doing anyway. Let's just like add another cherry on top of that fucking sundae that we already handed the left to begin with and go after gay marriage, which, by the way, the radical left never wanted gay marriage to be legalized in the first place. So now the conservatives are literally doing the dirty work of the queer Marxists, and they don't understand it because they do not understand the enemy that they're fighting, and they're just trying to get these victories to own the libs so they can feel morally fucking superior. I swear to God, can't they try to solve any real goddamn problems? Every time they do this stuff, every single time without fail, you can always trust the right to make the worst possible decision at every single corner because they don't bother to understand what they're fighting at all. Idiots.
Is having to face severe sanctions, potential sanctions for not sending their children to school, or being able to exercise their faith by preserving their children, their teenagers, from being exposed to worldly influences. And again, that was contrary to the Amish faith, which prescribed that at ages 14 and older, that's the critical time for children to be closer to home and not be exposed to the worldly influences of high school. So I think we're on all fours with Yoder. If the idea that we're just talking about mere exposure here, that is not something that would be cognizable, just sort of runs flat in the face of that decision.
Your approach focuses on, as articulated, sincere religious beliefs. How do you measure whether a belief is sincere or not?
Based on this court's cases, it's whether someone is expressing their understanding of what their religion entails. Thomas, I think, is this court's sort of canonical description of what it entails. You don't ask, does a majority of people of your faith agree with you? You're just saying, does someone, based on their understanding of what their religion is, believe this? And they're not making false representations. And I think that's how this court has consistently applied the sincerely held religious beliefs test. And there's no question in this case the petitioners would qualify. I don't think anyone has challenged the sincerity of their views.
Is there an example in this particular case of a articulated religious belief being rejected as insincere?
In this particular case, no. I don't think there is an example of that.
Ms. Harris, you've heard the discussion so far. And it's focused in part on what qualifies as a substantial burden. At one end, you might imagine a book being in the library. At the extreme other end, you might imagine a teacher coercing a student to write a certain passage or do a certain thing that's contrary to their religious beliefs. Where in that spectrum do you fall?
We might not even fall on the spectrum, because I think the question is not, are you objectively looking at the world and asking how does a child of a particular age or outlook feel about a particular encounter with a teacher or a particular material? It is, in the first instance, do parents have a sincerely held religious belief that their faith obligates them to shield children from particular material? And I think that's important, because if you take the opposite approach and say, people should get in the business of thinking about, our 4-year-olds more susceptible, our 16-year-olds sort of insulated, you start slicing and dicing among different faiths. You say that faiths that believe that 4-year-olds must be shielded might have a better right, or better free exercise right, than the Amish, who believe, for instance, that it's actually 14 that matters to their faith to shield people. That concern with religious discrimination is really, really important in terms of the first step of defining.
But if it's all about a sincerely religious parent wanting to shield her child, then to take what I think might be thought on some views as one end of the spectrum, a book in the library, right? And they say, well, my kid is not shielded from this book because there's library free time, and she could find this book on the library shelves. What would you do with that?
Right. So what we do with this is twofold. One is, I think you have a threshold state action question with respect to whether it's the child finding it, whether it's the school making it available. But even setting that aside,
making it available. The school is deciding how to spend their money and which books to buy. And
right. So I'll tell you that, just setting that aside, I think those kinds of questions do cash out, as petitioners are saying, with respect to, if you get past Smith, you end up in Smith, assuming that you are in strict scrutiny world, depending on the nature of whether the library allows opt-outs or not. I think it does cash out in strict scrutiny, because we agree with petitioners.
You would get to strict scrutiny, that sort of counts just because you find some kind of conflict, a religious parent saying, no, my kid would not be shielded from something that is in conflict with my religion. And so the only way for a school to win that is in strict scrutiny land.
Well, no, I think the school could win in a couple of ways. One is if they have a generally applicable policy, they don't allow opt-outs for anything. Obviously, they could be they could be in Smith world, but assuming we're in strict scrutiny world, this is how things work. I think the way that it works is, are you saying that schools have to operate as sort of policemen to make sure that there's no child at any point in the day who might run into a book or pages of a book that violate their parents' religious obligations? And I think then you're just in the same territory as United States versus Lee, or in Fulton, or in other cases that say at the point where you have a combination of you're essentially forcing the school or the institution to shoulder the burdens of reworking the institution and essentially giving that one person a right to restructure it for everyone else. That's not the kind of accommodation that is permissible under strict scrutiny. United States v. Lee is a good example where for the income tax.
I'm sorry, go ahead.
Sorry. Income tax, everyone accepted that the Amish carpenter at issue in Lee had a sincerely held religious objection to Social Security taxes, not part of their faith. But the court said, no, you can't just say that you get to ensure that everyone else doesn't pay their taxes, or that you get to essentially rewrite the income tax.
It's a good idea. Tag Tiffany too.
Because you can't have a sort of system
Tag
like
Tiffany
that. Now, we're in
Justice
the
and
opposite of that world
James.
here, because opt-outs
Just
with
because.
respect to pieces of instruction, the entire curriculum, with respect to extracurriculars, with respect to everything else, are a sort of very traditional feature of public schools, and indeed the means
So
by
with
which
respect to all of those things that you just said, curricular instruction, extracurriculars, blah, 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 that does not raise the Lee issue in your mind. You know,
It doesn't.
there the opt-out is necessary. You know, whatever you might think about, you know, this is about the kid's age, about the nature of the instruction, about anything else.
that's where we think we draw the line. And I guess
I mean,
that
there
would
is no
also-
line then.
No, I think there absolutely is a line. I mean, I think we've heard hypotheticals with respect to, can you essentially veto someone else's children being in the classroom? Can you veto a teacher being in the classroom? Can you make sure that no one else is being taught a particular book? And those, in our view, again, Fulton is a good example,
What
Barnett
would
too.
happen if, like, an 8-year-old, you know, there's a part of the school day where people show and tell and talk about things that matter to them and to their families, and an 8-year-old says, I want to talk about, you know, having 2 moms. Would another student be able to say, I'd like to exercise my opt-out now?
I don't think so, because in that particular context, what you're talking about is other students talking. Just as if there's a lunchtime conversation among students that raises various issues, schools and teachers and the board are not engaged in state action just by not policing everything that any student in the school says in any part of the day.
It's just what the teacher says.
It's what the teacher says. And again, I guess I would take it yet a further level. So there's teacher liability. And then for the board, of course, to be liable, you have Manel issues with respect to whether it's a policy. And just how this works out practically, teachers.
And do you think it's okay? Mr. Baxter's answered one of my questions.
Hey,
He said,
hang on,
he has
hang
no
on,
objection
hang
to the
on.
fact that, you know, the
Gotta
school would
pause
say, well,
this.
you know, you should leave.
Maria, thank you for gifting 5 memberships to the channel. Let's see who got the memberships. Oh, hang on. I got to change my computer screen. Tinge got 1. ZP got 1. Alexis got 1. Dawn got 1. And Rocky got 1. Congratulations to everyone who got a membership on the channel. Remember, if you are a member of the YouTube channel, you can join us for Spy Stream. I post the Spy Stream credentials to the community tab when we're doing them. Our next Spy Stream is tomorrow at 6:30 p.m. Eastern time, so you'll get a reminder of it when we do the stream. Other ways you can join Spy Stream are by becoming a member of my Substack, Karlyn, KARLYN.substack.com, by becoming a member of my Locals, my Patreon, or a Twitter subscriber, or a YouTube channel member, or getting lucky enough to be gifted a membership by the lovely Maria. And I hope we'll see people tomorrow for Spy Stream. Looking forward to it.
The room. And then if the next thing is, I don't want to leave the room, I want to be in the room, you know, in the same way as everybody else is. I just don't want them to be talking about that. Is that a claim?
We agree with petitioners. That would be that's just the same version of
Wait. Hola, taco burrito, por favor, hola. I have no fucking clue what you're ranting about. I think we've got a crazy leftist in the chat today. Hola. Yo quiero Taco Bell.
a veto that we already talked about. That's not a permissible, that would fail under strict scrutiny. That's not how opt-out works. And I think it's very telling.
Because the person could say, like, I'm not getting the same education, the same public good as everybody else is because I have to leave the room.
And I don't think that happens as a matter of practice. And the reason is, again, you have 5 states ranging from Pennsylvania to Arizona, Utah, Hawaii, Minnesota that have very broad opt-outs, even broader than any sort of constitutional rule being proposed here. And you don't see people saying, I have a sort of right under a state law action to like not have this particular opt-out operate that way. The way these have always worked is you either are sort of outside for a brief period of time or you're offered some sort of alternative. And again, this is not something that's hard for schools. It's something that schools have done for a long time. It is.
Sí, señorita, but can you say the title of the stream in Spanish? I know we're all very confused about what we're doing here, but can you say that in Spanish, por favor?
It's not a sea change. And respondents have the same problem, which is if you accept that it is some sort of level of compulsion that triggers it, they're accepting the same whole series of opt-outs and alternatives too.
Thank you, counsel. Justice Thomas, anything further? Justice Alito? Justice Sotomayor?
The injunction here sought by defendants asks for 2 things. Parents notice an opportunity to opt their children out of reading, listening to, or discussing the Pride storybooks. The injunction presumably would require what you say is not required, to take the books off the shelf, correct?
No, I don't think that's what they're requesting at all. And petitioners seem to have disclaimed that. Petitioners are saying they would like the ability to, they basically want the
to opt out from forcing the child to read the book.
So they want the
But that's
child
not
to
the
be,
words used here.
Yes, they want the child to be outside of the classroom if they are exposed to the book. They want the status quo ante that Montgomery County previously offered.
All right. So, but you're not objecting either to having the books on the bookshelf in the classroom.
We don't understand that to be the claim here.
All right. Now, they also asked the court to, quote, enjoin defendants from denying them advance notice.
Oh, Portuguese, whatever. I don't know how to speak either Spanish or Portuguese,
out of
okay?
any other instruction
Not my
related to
fault.
family life or human sexuality that violates the parents' or their children's religious beliefs. Is that an enforceable injunction?
Is that an enforceable injunction?
I don't know what related to family life would mean. It could be any picture, any book that talks about people getting married, interracial couples.
I think it's defined by the contours of their particular claim and by the way in which Montgomery County and the state of Maryland have defined
We
topics.
require injunctions to be more precise than that.
I think regardless of how the court feels with respect to the specificity of this injunction, it seems pretty definite in the context of the case. And with respect to the question presented, whether there is a burden if parents are not able to have the advance notice of opt-out of the material that their religious obligations prohibit, that's a clear burden.
Justice Kagan? Justice Gorsuch?
The way you briefed the case, the government's briefed the case, is a public benefit case, as you discussed. Another way to think about the case, as Justice Barrett was discussing with your colleague, was through the lens of Smith and whether the counties acted neutrally pursuant to a generally applicable rule. What are your thoughts about that? We have some statements that Justice Kavanaugh referenced from board members to parents and children, and we have opt-outs for all manner of other kinds of considerations for Valentine's Day and Halloween and other things. Would that be another way to approach this case?
It absolutely could be. I think that the way it would work would be you would find discrimination on the basis of religion, not just that there was not a generally applicable policy. So obviously non-generality would be enough to get you out of Smith. But I take the petitioners to be going further and saying there's evidence in the—
Yeah, but I know you sent the tweet already, but go and tag Tiffany and James in the replies. Yeah, edit it or edit or tag them in the replies, whichever. But definitely tag Tiffany. Tiffany is going to be very, very excited and very happy about that clip. And I just think that Tiffany especially is going to love it. The amount of times I said that she just got bent over and fucked in the ass at the Supreme Court. I think that Tiffany Justice is just going to be just really happy.
The record of more like a Lukumi-like animus type claim, where there is sort of the only explanation for the board's shift is they did not like the religious objections. They have expressed hostility in various comments to religion. So that is absolutely another pathway the court could go down. And again, we chose the public benefits path because on this particular record, it seems particularly sort of clear that parents have a sincerely held religious obligation that is being denied in this context. That would suffice to get to strict scrutiny and sort of go through the rest.
Well, I'm sorry. One other question. Some lower courts have taken the view that even if you have a discrimination against religion, so you failed the Smith test, that you still have to show a burden, a substantial burden in addition to that. And one might read a footnote in the Fourth Circuit's opinion to suggest that. Do you have thoughts about that?
This court has held in cases, certainly most recently in the Trinity Lutheran Trinity, that discrimination on the basis of religion, if you are treating people of faith worse or a particular religion worse or discriminating in the Lukumi sense, that triggers strict scrutiny.
Justice Kavanaugh.
Just to be clear, your position in this case is that you're not seeking to alter the instruction in the classroom or what's the content of the classroom. You're only seeking not for these children to be forced to remain in the classroom, correct?
Exactly.
And then if there is a substantial burden, you get to the next
Okay, I
step,
gotta
the
retweet that again.
analysis. Why do you think this is not generally applicable?
Two sets of reasons. One is that it's discretionary. So by definition, it's not generally applicable. The board can turn on a dime and change who gets exemptions, what kinds of exemptions are covered. And that's in fact the record here, that they changed overnight as to what kinds of exemptions they would allow. And two, in terms of lack of general applicability, is the patchwork of exemptions they currently allow. They allow exemptions for musical performances. I think they allow exemptions for dissection. They allow exemptions for Halloween.
Dissection, yeah, true.
For any kind of religious observances.
Thanks, Reagan.
On Saturdays or Sundays that might interfere with extracurriculars. The one thing they allow
True.
exemptions for sexual education in the classroom components. The one thing they don't allow is the exemptions for the storybooks. And that is sort of the hallmark of something that is not a generally applicable policy.
On your first point there, the alternative one about changing the policy, couldn't that be said about every policy that exists, even one that has no exemptions at all? Oh, well, they could change it tomorrow, therefore it's discretionary, therefore strict scrutiny. How would you answer that?
I would answer that by saying the court has looked at sort of legislation and other sort of things that are binding differently and said, if you have a law that says there's no exceptions, it's a different situation from if the decision maker tomorrow just retains flexibility. I mean, if you think about Fulton, the way in which the court thought about case-by-case discretion in that case, if you have a decision maker who can just say, I'm going to, in my discretion, reverse course, decide to give you a one-off opt-out or a categorical opt-out tomorrow, it seems hard to see why that would be generally applicable. And again, the fact that the board did something similar to that here.
We don't need to address that here, I suppose, because of the exemptions that exist for other things makes it non-generally applicable in your view.
Yeah.
And then on strict scrutiny, why does the county fail strict scrutiny?
The county fails strict scrutiny because the question is whether the county has a compelling interest. Here, their asserted interest appears to first and foremost be in administrability and not granting opt-outs to the petitioners. That's the way the courts framed the burden analysis in Fulton and Yoder. And so it's key to a sort of not granting the exemptions. And it is very, very hard, even on this sort of preliminary injunction record, to understand why it is not administrable to offer the opt-outs in this particular context that they used to offer, but offer a host of opt-outs for virtually everything else under the sun and not have all the same concerns flooding forward, especially given that they have, in addition to the things that they have identified in their policy, conceded that they would need opt-outs for things like exposure to images of the Prophet Muhammad or any instances where classroom instruction rose to the level of compulsion under their view. And so I think their line drawing problems really would doom any kind of attempt to satisfy strict scrutiny.
Is the United States aware of any other school board in the country that's done something like this?
We aren't, I can't vouch for it not happening, but I think more relevantly, we're aware of many, many states and school districts that take the opposite tack and allow opt-outs far beyond any kind of constitutional rule that would be adopted in this case.
Thank you.
Justice Barrett.
Ms. Harris, so there's a lot of concern about line drawing and what this would mean, and maybe some of that would be handled under strict scrutiny or under Smith. I mean, it's not saying that anybody wins or loses if we're just talking about initial steps, but to the point of line drawing, is there a way, let's imagine that the court decided that there was a burden here, that a free exercise right was triggered, that the government thinks we should be careful about to not implicate other things. I'm thinking about what if a teacher was transgender, and the student was very respectful to the teacher, but didn't want to use the pronouns, and the parents didn't want the child to use the pronouns.
It's a good
that say,
question, Amy.
Call the teacher Mr. When she was transgender, when the teacher was transgender. Same for a student in the classroom. Those might present different issues that would be more difficult. So is there something that the government has in mind?
Hang on,
that
hang
would
on,
be-
hang on. Pause. So the very best way, unless you have a really specific suggestion, the very best way to get in touch with me is to come to my streams and stay. Oh, now you're a former leftist and you're okay. So the very best way that you can help is by coming to the streams, learning the information, participating in the chat. And that's the best way to do it. And if you have something additional that you want to do, you can DM me on Twitter. You can find my contact. You can send me an email through my website, decodetheleft.com. You can do that. But honestly, the very first thing most people need to do if you actually want to be helpful is you need to come to the streams and learn my content, because if you haven't seen my content, you don't understand the left yet. I promise you, even if you're a leftist, I promise you don't understand how bad it is. So that's the first thing that needs to happen. Because if you don't understand the left, then there's just not that it becomes really difficult after that. So that would be my recommendation. Thanks for stopping by.
Some limiting principle.
Yes, so just to take the limiting principle first and then your pronoun hypothetical second. With respect to the limiting principle on what a burden is, I think this is the easy case because you have parents' religious obligations and the obligations encompass being exposed to material.
Oh,
just
bro,
an outright prohibition.
Bro,
but
you've written essays. You've written essays. I've written hundreds of articles. I've written multiple books. I have consumed thousands of hours of content. I have gone undercover at their events on multiple occasions. I have infiltrated more of their events than any other independent journalist in the country for years and years and years. I'm glad that you've written essays, but the answer that you're going to get, and I'm not going to take your fucking, bro. If you want to help, come to the streams and learn the content. If you don't do that, and your answer is, I know everything because I wrote an essay, it's not going to work out. No, you don't understand them. Okay, so this is the last thing we're going to acknowledge from you right now. If you think they're a victim culture, you do not understand them in any way. And so now we're going to see if you show up and learn. If you show up and learn, then you can come and help. If you don't show up and learn and you keep arguing and insisting that you know things that we all know, just so you understand, everyone that's a regular in my chat knows you don't know what the fuck you're talking about. And we're willing to teach you and we're willing to help you learn and we're willing to help you evolve your perspective on this, but not when you come into our space and claim that you know more than us, because you don't. There is a hierarchy here. I'm at the top of the hierarchy. There are people in my chat who've been watching my content with me for 4+ years. They are right below me in the hierarchy. You just got here. You're way the fuck down here. If you want to be of help, you need to come and learn.
I think Professor Gorgas's article is actually a very good guide to different kinds of burdens that might arise in this context or others that wouldn't qualify. So take the hypothetical of parents want to opt out from school for a month to take their kids on a religious pilgrimage. If your faith is indifferent to doing so in September versus during spring break or summer recess, you don't have a burden on your religious exercise because you have available alternative.
No, it doesn't. That's not what it means. That's not what it means at all. So your job right now is to come and learn. And that's the last I'm going to say on it. And my chat can, and I'm not even going to correct you on that. My chat, if they feel like it, they can correct your incorrect perception about what the definition of capitalism is according to the left.
Means of doing your religious exercise that don't require the opt-out and don't really put you to the choice that we're talking about. So when you're thinking about things that aren't sort of the prohibition on exposure things, I think there are real teeth in this doctrine.
Good job, Bobby.
A lot of hypotheticals that you can think of in the school
Bobby
context
swooping in there with a question.
With respect to your pronouns hypothetical, I actually think that's a case that raises even more concerns in the sense that you also have, and this is what the Court of Appeals cases bear out, potential compelled speech concerns with respect to you are requiring everyone else in the classroom, first of all, free exercise issues, but also compelled speech issues to refer to a particular person by pronouns. That's how the cases are kind of getting litigated out in the lower courts right now.
Thank you.
Justice Jackson?
I guess in following up on that, I'm just not sure I understand your answer. So is it a burden for a religious student who is being taught at home and through their religion that gender is not a situation that can be changed? People should not be in a transgender circumstance. Is it a burden for them to be in a public school classroom where
oh my
the
God,
teacher
this
is referring
woman
to another student by what this student believes is the wrong pronoun or whatever?
Well, I think the relevant burden there would be the parents' religious exercise, as we've conceived of like the nature of the religious beliefs in this particular case. As petitioners know, you could also have questions with respect to the students' free exercise rights. I think that's a
So
trickier
is it a
question.
burden on the parent to have their child in a class?
Space Jack asks, what's the distinction between private property and means of production? Private property means your ability to own a home, your ability to own land, your ability to own an apartment rental that you rent out as a landlord, your ability to own intellectual property, your ability to own a private business, whether or not that private business is big or small. Your parental rights are considered to be a form of private property. Your individual liberties are considered to be a form of private property. So when you ask me what the difference is between parental rights and the means of production, I would ask you what the difference is between a machine in a factory and parental rights, because that is what we're talking about. Saying that capitalism just means the means of production, that is a really outdated, antiquated way to look at how the left perceives capitalism, because the left perceives capitalism as both an economic model and a cultural model. And the means of production are only the economic model. And then you're only talking about the bourgeois owners of the giant fuck off factories. And that's not the way our world works. It's also not the way the left sees what capitalism is. The definition the left has of capitalism is significantly broader than a machine in a factory. And until the right starts learning this, they will perpetually lose to the left, because the reason this Supreme Court case is even fucking happening is because parental rights are considered to be a form of private property under capitalism. That's what this case is about. That's all this is about. Parental rights as private property. Well, you're not understanding that either, because when they say private property, what they mean is bourgeois property. Again, that is property that you can use to create personal, individual, privatized wealth. Private property, again, this is the second time I'm saying this. Do not make me say this a third time. Private property, private bourgeois property is your ability to own a home, your ability to own land, your ability to own an apartment rental that you rent out as a landlord, your ability to own intellectual property, your ability to own a private business, whether or not that private business is big or small. Your parental rights are considered to be a form of private bourgeois property because it involves inheritance and passing property down from father to son or whatever. Your individual liberties are considered to be a form of private property. Individualism itself is considered to be a form of private property because individualism is the only way that you amass individual property that is exclusive to you and not under the collective control. When they are saying personal property, what they mean are things that you own that do not allow you the ability to create personal private wealth. So a phone, a car, a pet, a book. Those are your fucking toothbrush. Those are considered to be personal property, and that is the distinction between personal property and private property. And that is the trap that people like you always walk into because you don't understand what the definition of capitalism is in the first place. Do you have any other questions? Does anyone else want to challenge me on what the left means by this? Oh my, okay. Bro. Are you stupid? We've stopped the entire stream for Space Jack because Space Jack is not fucking listening. So now you're going to get the fucking hammer. There's no difference between private property and the means of production. What's the difference between your home and a factory? Answer the question, this specific question. What is the difference between the house that you live in and a factory? That is the only thing I want to see you say in the chat. If you do not answer the question in 1 minute, you will be banned for the rest of the day. What is the difference between your home and a factory? Go. Do, 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 do. Do 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 psh do psh do boom boom. We're waiting for your answer, Space Jack. We've stopped the entire stream just for you because you refused to listen to the very clear explanation you were being given. What is the difference between your home and a factory? No, 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 no. You are answering the question I'm asking you. If I see anything else come out of your mouth other than an answer, you are getting banned for the rest of the chat. What is the difference between your home and a factory? The scale of the thing? The scale of the thing doesn't matter to the left. The scale of the thing doesn't matter. Your home is a form of bourgeois private property. Where do you think squatting laws come from? Where do you think the idea that anyone can squat in a house and you can't fucking evict them if you're the owner of the house? Where do you think that shit comes from? It comes from the left because they consider your home to be a form of private property. They believe that they can commandeer homes that are owned by people that people don't live in to give them away to other people. That is your home as a piece of private property. Do you understand the difference or don't you? We're waiting. You're still disrespecting me by not answering the question I asked you, and I really dislike it when people come into my chat and spit in my face after sitting there and taking my time and my energy for free. So are you going to answer my question, yes or no? And actually, you know what? You have 20 seconds to answer my question because I'm not going to continue with this. What is the difference between your home and a piece of private property? Do you understand or don't you? You have 15 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. All right, ban it is. Goodbye. You're not going to talk for the rest of the stream. Now you can come back, but you're not going to talk anymore today. We're putting you in a 24-hour timeout. And we will see you if you ever come back. But if you ever come back and question me again, you will be fully fucking prepared for the fact that you do not know as much as me about the left. That there is no gotcha that you can ask me that I don't know how to answer because I've been asked all the gotchas a million times because I've been doing this shit for 4 fucking years, almost every day of my life. And at some point, people will learn that and they will start either listening or they will go bother other people on the internet. And either is okay with me.
Room with a transgender student and the teacher is referring to them by pronouns that the parent thinks is inappropriate.
I mean, I think even under respondents' view that would in fact constitute a burden on religious exercise, and here's why. It is a burden on religious exercise and the parents' view because not only do they have a religious obligation to ensure that their children...
Listen, I know I said I was going to be nicer to people, but you cannot expect me to be nice to people who come into my chat, ask a question, that question is answered, they don't listen, they ask the same question again, they question the answer again, and it's like over and over and over again. Part of the reason I'm driven insane is because I have to say the same thing over and over and over again every day of the week ad nauseum until I am dead. And then when people don't listen, because they think they know better because they read an article on the internet one time, it's infuriating. If people are here, they need to be listening. And they need to accept that there is a hierarchy on this channel. And yes, I do know more than you. There is a very rare exception that knows more than me. There's very, very, very rare exception. And by the way, if you do actually know more than me, you're probably not going to come into my chat and tell me you know more. Because what you're going to do is come in and demonstrate that you know more, and you're going to understand exactly what I'm fucking talking about. And if you don't understand what I'm talking about, then you need to listen. Well, no, it is their fault, Bobby, because it is not their fault that no one else is talking about this. It is their fault when they come into my chat and they do not listen, and I'm nice to them and they don't listen, and then I'm nice to them again and they don't listen again, and then I'm nice to them again and they still don't fucking listen, and they act like they know everything when they don't. So it's not their fault that their influencers are lying to them. But the moment that it's pointed out, and by the way, I wasn't the only one saying it. There were people in the chat saying it. The moment it's pointed out, you got to start to be an adult and and I'm not saying you specifically, Bobby, but like you got to start to be an adult and put on your big boy pants and take in that information. You've learned here. You didn't think you could learn this stuff when you started. You came into the chat. I'm not trying to make fun of you, Bobby. But you came in my chat and I yelled at you one time and you're like, I'm autistic. I don't know. And I said, I have higher expectations for you than that. And guess what? You kept coming back and you learned the content. And now you're the one that asked him what capitalism was. So don't tell me other people can't learn. You have. And it's because you listened and you showed up over and over and over again. So you learned. If people don't want to do that, they just won't learn, and that's okay.
It's sort of exposed to the idea that you must sort of recognize people's pronouns in that particular way. But I think even under respondents' view, there's a level of compulsion or affirmation of a particular view of how someone's pronouns should work out.
And it doesn't matter that the parent could send their kid to a different school because they don't like this environment. I mean, they're not, you agree that they're not being compelled to actually go to that school where this sort of thing is happening that they disagree with.
I think 2 points on that. One is that actually shows the burden because you're being forced to forgo the benefit of a public education. And
well, we'll get to that. School. I'm just trying to understand.
Yeah, I think
I'm trying to. So you're saying even if the parent has a choice to put their kid in another environment that doesn't do the kind of thing that they object to, it's still a burden if they opt to put their child in this environment.
Absolutely, unless you want to overturn Burnett, because Burnett too, I think, had that same choice.
Let me ask you about just following up on that choice. So is it really confined to the public school context? So in that same scenario about foregoing a benefit, what if the government puts up ads on public transportation that informs the public that the clerk's office, the government's clerk's office performs and certifies gay marriages? And this is on a bus, this is on the subway, and children can see these ads that are talking about state-sponsored gay marriages. And what I guess I'm trying to understand from your argument is whether it substantially burdens the religious exercise of parents whose religions teach that marriage is between a man and a woman, to ride on those, to have those ads displayed.
Oh my God, I hate this
on
woman.
public transportation.
Yeah,
not
because
she's black, it's because she's
like how the
annoying.
government speech inquiry would sort of cash out in that context and what kinds of challenges you can bring to transit. But I would just say as a more general matter, our position is not limited to the idea that if there are other contexts, I mean, if there are other contexts like take Bowen, where you're being forced to use social security numbers by the government, and that violates.
No, I want this context. I want
okay, but I'm just saying, like, the answer is going to be yes in terms of like.
The answer is going to be yes.
In terms of it applies to other contexts.
So I guess I don't understand how that squares with our cases about not making the government change its position or do things just because of your religion. I mean, we have a public bus, and the person can choose not to ride the bus if they don't want their children exposed to the ads that are on the bus. But you seem to be saying that because the bus is a public good, the religious parent has the right to tell the bus people and the state that they have to take those ads down because they don't want their children to be exposed.
I should be more precise in terms of how I'm answering the hypothetical versus the general extension of the cases outside the school context.
Yes, she did.
I obviously think that the range of you can't be first to forgo a public benefit extends beyond the school context because the respondents are asking for the reverse, to confine it to everywhere except for the school context. With respect to your hypothetical, I think you're getting into the question of how far does like the Ling decision extend with respect to government property? Can you force?
No, I'm just trying to find a public benefit. You have schools, you say, is a public benefit that parents are being forced in a way they're to give up if they want to have an environment that their children is not exposed to these sorts of ideas. I'm just trying to find an analogous public benefit outside of the school context and ask you whether your position is that it substantially burdens the rights of religious parents if there are advertisements on a public bus that say things that...
This is the worst thing that Joe Biden did to us, was give us Ketanji Brown Jackson. This woman is so annoying. She's so dumb. I'm going to say she's a DEI hire. She's absolutely she is not smart. Like, the arguments that she's making are not smart. And by the way, like, I don't actually care that she's a black, I don't care that she's a woman. I don't care about like any of these things on the face of it, except that this woman is obviously not the most qualified person to be on the Supreme Court, just on the basis of the stupid moronic arguments that she's making. This is not an issue of her skin color. If it was, if there was a very smart black woman sitting on the Supreme Court asking intelligent questions, I would have no fucking issue with it. Clarence Thomas is black. He's asking intelligent questions. I don't care about that. If Clarence Thomas was a woman, I wouldn't effing care. Amy Coney Barrett, woman, I don't care. She's asking intelligent questions. And by the way, Amy Coney Barrett is more left than I am, and that makes me uncomfortable sometimes, but I think she's brilliant. Neil Gorsuch is more conservative than me on some issues, but he's brilliant and he asks great questions. And so it's like, this woman, though, she is a DEI hire. Yeah, we do have Disenraged tonight. We're talking about Jesus tonight at 9 p.m. So we better actually listen to this stream. Otherwise, we're not going to make it to the Disenraged stream.
They don't want their children exposed to.
So again, I think at the first stage of the burden inquiry, it depends on whether you're in the wing category of cases where you're saying I'm essentially burdened by something that's on government property, or you're in the sort of stage here where we're not talking about that context, but just to abstract outside of that, there are obviously going to be contexts besides the school context in which we would agree that there is a burden. Again, I think Bowen is really the best example where parents would be, if you take the Bowen hypothetical that was reserved, parents are forced to use social security numbers to get benefits, right? To apply for various things. That burdens a religious exercise. So yes, it applies in those contexts, but I think that is that's sort of a feature of this court's jurisprudence, because this court has not said that public benefits can't be burdened.
Isn't a feature of our jurisprudence that we haven't said before that mere exposure to these sorts of things create burdens? I mean, I understand that most of our jurisprudence in this area is about forcing people to affirm, the Pledge of Allegiance, forcing people to go to the public school. It'd be one thing if the state, in my hypothetical, said everybody has to ride this bus. Just like the state used to say, everybody has to go to public school, the Amish have to go to public school past 16. But if you have an option to do something else, I guess I'm just worried about suggesting that exposure to things you disagree with in a situation in which you have an option not to expose yourself to that because you can do something else counts from the standpoint of substantial burden.
So 2 points. One is, I think there's two concepts in here. One is with respect to the concept of like quote unquote mere exposure versus beliefs. I think that line is not a line that can be held without discriminating on the basis of religion. I think if you had a situation where, let's say Ms. Sherbert believed that she couldn't view images of the Prophet Muhammad, the only options for her Saturday employment for whatever reason involved seeing that, or involved employment that would have violated her obligation not to view other things that are religiously objectionable to different faiths, I think it would be the same setup. It wouldn't matter that it's unemployment benefits versus a school context. Now, second issue with respect to can you avoid it through other means? I think this court in Fulton confronted a very similar situation. The court did not say, Catholic Social Services, you have a mission that's religiously motivated of making sure you provide for the needy of Philadelphia. Instead of doing so through foster care placements, you have lots of other ways to serve those children, so go off and do so, even though the only means of serving foster care children through Philadelphia required violating their sincerely held religious beliefs in terms of affirming same-sex marriage.
Thank you.
Thank you, counsel. Mr. Schoenfeld?
Mr. Chief Justice, and may it please the court. Every day in public elementary school classrooms across the country, children are taught ideas that conflict with their family's religious beliefs. Children encounter real and fictional women who forego motherhood and work outside the home. Children read books valorizing our nation's veterans who fought in violent wars. And children in Montgomery County read books introducing them to LGBT characters. Each of these things is deeply offensive to some people of faith, but learning about them is not a legally cognizable burden on free exercise. Adopting petitioners' view of the case would conscript courts into playing the role of school board, a task for which this court has recognized they are ill-suited. And a constitutional requirement to provide opt-outs from anything someone finds religiously offensive would mean public schools must find alternative classrooms, supervision for young students, and substitute lessons each time a potentially offensive topic arises.
Cookies!
That is not what the Constitution requires, particularly given the special characteristics of the school environment.
Wow.
This court has made clear that exposure to offensive ideas does not burden free exercise. And it has held that the government is not required to do its daily work in ways that make it easier for parents to raise their children in the faith. Given the diversity of religious beliefs in America, petitioner's rule would require courts to adjudicate an infinite variety of curriculum challenges brought by parents with different religious beliefs. That is not hypothetical, as 40 years of litigation on these issues makes clear. The books at issue here, 5 among hundreds in the curriculum, are meant to foster mutual respect in a pluralistic school community. MCPS makes explicitly clear that students do not need to accept, agree with, or affirm anything they read or anything about their classmates' beliefs or lives. The lesson is that students should treat their peers with respect. I welcome the court's questions.
Couldn't you solve those differences simply by restoring the opt-out?
Your Honor, I think in this case, the record makes clear that the school district did try to honor the opt-out, and at some point it became infeasible. Certainly there are circumstances where the right decision a school board might make in view of the particular needs of a community is to offer the opt-out. It's a different question from whether it's constitutionally required.
How would you distinguish your case, this case, from Yoder?
I think Yoder involved a religious obligation that adherents remove themselves physically from society. So what was at issue there was the conflict between the Yoder's sincerely held religious beliefs that they needed to remove their children from society in order to provide them with the vocational training that the religion required, and that conflicted with Wisconsin's criminal compulsory education law. Yoder was a very clear application of Meyer and Pierce that simply went to the parents' right to determine where their children would be educated, and not anything about what would go on in the schools. And Yoder, in fact, makes clear that it wasn't opining on the question of whether parents have any prerogative to dictate the discrete aspects of the curriculum, a clarification both Meyer and Pierce before Yoder themselves made.
So Yoder is a complete withdrawal of the students from school, and you say that's not as drastic as picking and choosing certain messages that the parents don't think their kids should hear?
Precisely. And again, I think Yoder was a direct application of Meyer and Pierce. Meyer and Pierce said 50 years before that parents get to decide whether to enroll their children in public schools. And Yoder simply recognized the right of the old order Amish to withdraw their children from school at age 18. Meyer, Pierce, and Yoder are all very clear that they are not offering any opinion on what the rights of parents are once they enroll their children in public schools for precisely that reason. It becomes infinitely more complicated to honor parents' individual religious beliefs once they're in the public school environment.
Or why wouldn't a parent argue that the opt-out is a more specific version of Yoder, because you're simply opting them out of specific programs as opposed to the entire school program?
It may be for one parent that is a more narrowly tailored approach, but the question presented here is whether it constitutes a burden to be exposed to this sort of instruction. And when parents have a right to invoke the free exercise clause to shield their children from all manner of offensive curriculum, I think it becomes infinitely more complicated.
Counselor, you said that nothing in the policy requires students to affirm what's being taught or what's being presented in the books. Is that a realistic concept when you're talking about a 5-year-old? I mean, do you want to say you don't have to follow the teacher's instructions, you don't have to agree with the teacher? I mean, that may be a more dangerous message than some of the other things.
Well, there are express directives in the support materials that Montgomery County provided along exactly those lines. But Your Honor, I would point the court to Barnett, where the kids were young, they were 8 and 10, and the court made a distinction between being required to pledge allegiance and affirm a belief in a graven image in that case, and merely being required to remain passive during the pledge ceremony and being instructed on what the pledge was, what the flag was, and what it meant.
Well, that's a particular ceremony, which I think I would sort of put aside when we're talking about the basic instruction here. You know, read this, or this is what it shows on an issue that presents serious religious objections for the parent. So, I mean, I understand the idea when you're talking about a sophomore, junior, whatever in high school, you know, where the point is you want to sort of push back on some of this, but I'm not sure that same qualifying factor applies when you're talking about 5-year-olds.
Well, so if that's relevant to the question, Your Honor, then I think that the line that we advocate between exposure and coercion is the relevant one. And there may be circumstances where, given the age of the student or given the particular presentation of information in the classroom, a plaintiff may be able to make out a case that their child is being coerced. But the court, I think, has to accept what Montgomery County sort of represents as the basis for the presentation of this curriculum. And what's in the record are directives to say, for example, I understand that is what you believe, but not everyone believes it. In any community, we'll always find people with beliefs different from our own, and that's okay. We can still show them respect.
Counsel,
That's exactly.
Counsel, on that score, the exposure line versus coercion line you ask us to draw, how does that play out in the case of the Muhammad image for a Muslim student? I didn't see you answer that in your brief.
So I think we do answer it in the brief, but to answer the question directly, assuming that the prohibition is on viewing a visual depiction of the Prophet Muhammad, in those circumstances, the school is coercing an individual to act contrary to a religious belief.
Even though just being exposed to the image.
The
exposure there is coercion in your view.
I think it's the difference between exposure to ideas and activity that coerces you to engage in conduct that is in violation of your beliefs.
So when the idea is the image of the prophet.
I think the image is the image. In other words, if there were a book.
So it's an image that makes the difference rather than an idea.
I think it's conduct that makes the difference. And I think
how do these?
So if there were a book.
How do these people think indoctrination happens? They're like, we're just exposing you to ideas when you're too young to question them in elementary school. We're not indoctrinating you. We're just exposing you to the idea when your brain hasn't developed a point where you're able to think critically about it.
Described someone drawing an image of the Prophet Muhammad. I don't think a parent would have the ability to object, even given the religious prohibition at issue, on simply being exposed to the idea that people might depict the image of the Prophet Muhammad. Being required to view the depiction of the Prophet Muhammad in contravention of a religious objection is being required to engage in conduct.
Well, the child is saying passively, and the teacher's just reading a storybook.
I think if the storybook features the depiction of the Prophet Muhammad, that is a compulsion to engage in conduct that violates your religious belief.
Okay.
Now, again, I think what's important here is that this goes simply to the question of whether the right is being burdened.
No, I
Very hard.
understand that. Okay.
But it's very-
Counsel, I do understand that. I have a slightly different question. And you say this is only about exposure, but we also have in the record some guidance materials for teachers, and one of which is if a student says that a boy can't be a girl because he was born a boy, teachers to respond that comment is hurtful and we shouldn't use negative words to talk about people's identities. Is that exposure, or is that something else for a 3 to 5 year old?
So 2 points on that, Your Honor. The first is that the record is seriously underdeveloped on whether and how these support materials are used. These were recommended potential answers for questions that students might pose. There's nothing in the record about whether any teacher—
Okay, let's say a teacher does as instructed though, and uses that. Is that exposure or is that coercion in your world?
I think that as Your Honor has recited it, it is exposure to particular ideas and teaching students to be civil in the classroom. There are certainly circumstances where use of that script in a particular context could give rise to a claim of coercion. If, for example, and again, I think the distinction between exposure and coercion is one that's quite familiar to the court. The court undertook precisely that analysis in Kennedy and in Town of Greece versus
I'd like
Gallagher.
to talk about Kennedy and maybe Masterpiece a little bit too, where, forget about Yoder and substantial burden, the court focused on, and particularly Masterpiece, the statements of those involved in the policy. And here we have some statements from board members suggesting that students were parroting their parents' dogma, suggesting that some parents might be promoting hate, and suggesting that it was unfortunate that they were taking a view endorsed by white supremacists and xenophobes. I didn't see you directly address those comments in your brief, and I just want to give you an opportunity to do so here and ask you, does that suggest a hostility toward religion akin to what we found in Masterpiece? And why wouldn't that be enough to trigger strict scrutiny on its own?
In the first place, the question of whether there's a burden, I think, is a relevant starting point. And so I don't think we get to Smith or
we found in Smith, and in Smith, if you're not neutral, if you're expressing discrimination towards religion, and Masterpiece, if you're expressing this kind of hostility toward religion, you go to strict scrutiny. And we don't need to get into all the rest of these coercion versus exposure and doctrine about what constitutes a substantial burden.
Respectfully, I think those cases, there was a clear burden in each of those cases. So as the question comes before the court and how you define the burden, I think that still needs to be answered before you get into any of the anterior parts.
So you take the view that even if you have a non-neutral policy, and even if it was motivated by hostility toward religion, and even though the parents claim a burden, you still have to somehow meet an additional objective substantial burden test?
Correct. I think that there's a prerequisite.
Okay, I got your answer. I appreciate that. Do you want to comment about those remarks and what they represent?
Certainly. I think the position of the board with respect to this policy is clear. The board adopted neutral policies where it allowed opt-outs for all reasons, including religious reasons, in a sincere effort to accommodate the viewpoints of all of the members of the community. It tried that. It failed. It was not able to accommodate the number of opt-outs at issue. It then adopted an entirely neutral policy where no opt-outs were permitted. I think some of those comments have been taken out of context. I think many of them post-date the actual withdrawal of the opt-out right by the school board. And
so I understand that some of them were in response to a parent meeting after the withdrawal. So do you want to defend them at all, or have any explanation for them that it isn't based on hostility toward sincerely held religious beliefs?
Your Honor, my answer is that I think the statements speak for themselves. They are taken largely out of context, I think, in petitioner's brief.
Do you have context you wish to give them?
They are intemperate statements. I don't deny that. I think the question of whether they motivated the school board to adopt a policy that discriminates against people on the basis of religion is not borne out by the record. And finally, I just point out that I apologize.
No.
No, please go ahead.
Answer. Okay, I just wanted to ask, so there's been some question about the record and whether these were just books on the shelf or whether they were actually used in the classroom. How could it be that the opt-out policy became unmanageable if they weren't part of the instruction? Because if they were just on the shelf and the parents sought an injunction saying we don't want to be taught, then presumably that's no big deal. You'd say, okay, fine. You're not going to be taught. There's nothing to opt out of because they're just on the shelf.
Certainly, there were certainly classrooms
good point, Amy Coney Barrett.
Read out loud, or they were pulled off the shelf by a student, and the student read it with a peer or many peers. They were used in the classroom the way that any book is read in the third or second grade.
And so that is in the record that they were used in the classroom, and it is in the record that the teachers had this discussion material. And in the the intersection allies. The discussion guide is actually part of the book. The explanations about gender and all of that sort of thing are not even part of the separate instructional materials, but part of the book itself. All of that is in the record, right?
Absolutely. So with respect to how the supporting materials, even the ones that are an adjunct to the book, like intersection allies, absolutely in the record. What's also in the record in the Hazel Declaration is that some use of the books was required. Do I know how it was actually used in all of the classrooms in 130 elementary schools? No. But the expectation is that they're going to be used just as any other curriculum material is used.
So it seems to me then that really the lack of a record matters most if compulsion is the standard, right?
Absolutely.
Because if compulsion is the standard, then I can see why we would need more in the record about, if it really is required that the teacher would have to ask a student to renounce beliefs or to abandon beliefs in some way, then we would want to see record evidence. But if it's not compulsion, if it's interference, in the way that your friend on the other side has articulated it, then it seems to me we have that in the record because we have the books being read in the classroom. It's not mere exposure.
So I think exposure to ideas in the classroom, whether they come in the form of a teacher reading a book to a student or a student reading a book to a fellow student, that is certainly on our side of the line between exposure and coercion. There's a set of facts where the presentation of the material in the classroom might give rise to coercion.
Well, it's not just exposure to the idea, right? If it's exposure, if it's presentation of the idea as fact, that's different, right?
I don't.
It's not just some people think that's exposure. Some people think X, some people think Y. It's saying this is the right view of the world. This is how we think about things. This is how you should think about things. This is like 2 + 2 is 4.
I disagree with that characterization of the record. So I think that
let's say that is in the record. Okay, let's say it's not just some people think X, other people think Y. We live in a pluralistic society, period. Let's say it is some people think X and X is wrong and hurtful and negative. Is that? I mean, that's more than exposure, I think, on your theory.
That is more than exposure, and those facts may well be relevant to a coercion claim. I don't think that is what the record.
But if it's not coercion, let's say that I think it's something less than coercion. You concede that would show, interference with, hindering of a parent's right to.
I don't, because I think the parent's right to shield their children from offensive curricular materials is no greater than the child's right to be free from offensive curricular materials. And if on our theory, children have no right to be shielded from offensive curricular materials that share a view that conflicts with their religious belief, parents don't have
the right to shield their children from offensive materials? Excuse me, attorney for the school board? Again, please.
It's right to.
I don't, because I think the parent's right to shield their children from offensive curricular materials is no greater than the child's right to be free from offensive curricular materials.
Wow.
And if on our theory of the case, children have no right to be shielded from offensive curricular materials that share a view that conflicts with their religious belief, parents don't have a greater right than to shield their children from.
Counsel, can I ask you?
I just have. Oh, sorry.
Go ahead.
I just had one question to follow up. I just want to ask you quickly about this idea of whether this is a public benefit or compulsion, given the compulsory attendance law. Is it kind of your position that because parents have the right to send their children to private school or to homeschool, that in and of itself is the opt-out?
No, that's not a position we've taken here. The compulsory education analysis has always been part of this court's coercion inquiry. So in Lee versus Weissman and Santa Fe, the fact that the children who were enrolled in this public school were required to be there for the graduation ceremony, and there's a lot of discussion about whether it is or is not. I think the compulsory nature of public education, where a student is enrolled in public school, is relevant to whether there is coercion. It is one factor among others. The fact that a student who is enrolled in a public school and needs to be there is exposed to offensive ideas simply goes to the question of whether we are right that exposure to ideas, regardless of whether they conflict with religious belief, constitutes a burden on free exercise.
So it doesn't matter to you that you could go to religious school or private school or homeschool for purposes of the analysis, the legal analysis?
For purposes of the analysis, correct.
Mr. Schoenfeld, can I make sure I understand what you mean by coercion? You say in your brief that there are 3 things that cannot be done. The state cannot say you can't go to a private school or a religious school. The state cannot say you must affirm certain beliefs. And the state cannot say that unless you, that you're going to be disqualified from benefits because of your religious beliefs. Is that the universe? Those are the 3 situations in which there's coercion?
No, Your Honor. I think what this court said in Ling is that coercion is found when there's a tendency to coerce individuals into acting contrary to their religious beliefs. So, for example, in the
it goes further. It goes further than that. So, suppose a school says we're going to talk about same-sex marriage, and same-sex marriage is legal in Maryland, and it's a good thing. It's moral. It makes people happy. Same-sex couples form good families. They raise children. Now, there are those who disagree with that. Catholics, for example, they disagree with that. They think that it's not moral, but they're wrong. And
yeah, I'll clip
they're
that.
Bad, and anybody
Don't
who doesn't
worry.
accept that same-sex marriage is normal and just as good as opposite-sex marriage is not a good person. Now, What if that is what the school teaches students?
I think that's absolutely coercion. I think where I found the line between exposure and coercion in your presentation, Justice Alito, was this is the state of the law in Maryland and elsewhere in the United States. People can fall in love, get married, even same-sex couples. Some people believe in it, Catholics don't believe in it, and then it stopped. And then it was directly derogatory of a particular set of religious beliefs. It was avowedly so, and that I think under any fair reading would give rise to a coercion or a discrimination claim.
So you can, the school can teach students certain moral principles that are highly objectionable to parents, and that's okay.
Yes.
They can't opt out.
That does not burden their free exercise. There's no constitutional requirement of completeness in these contexts. A school could easily teach that evolution is one theory and it is the correct theory, and I don't think there's any constitutional problem with that. Certainly if a student taking a test said, you've taught me about evolution, here are the principles of evolution, I'm reciting them to you, but I don't agree with that, and my faith teaches me differently, no teacher would penalize the student for saying that, and if the teacher did, that would certainly give rise to coercion.
Now let me, the opposite end of your spectrum of possibilities is exposure, which you talked about over and over. What does that mean? I would think that exposure, and we can take the example of same-sex marriage. Again, exposure is telling the students that there are a lot of people who marry a person of the opposite sex. There are also people who marry a person of the same sex, period. Leave it at that. That's exposure. If you go beyond that, is it still exposure?
It depends on the context. I mean, I think Uncle Bobby's Wedding is teaching third graders or second graders precisely that. It's telling it through a story. And the fact that in that case, it's Uncle Bobby and Jamie rather than in Uncle Peter's Chinese American wedding, it's Uncle Peter and his wife.
Well, don't you think, I mean, Justice Sotomayor and I were discussing this before, and we could have we could have a book club and have a debate about how Uncle Bobby's marriage should be understood, but I think it clearly goes beyond that. It doesn't just say, look, Uncle Bobby and Jamie are getting married. It expresses the idea subtly, but it expresses the idea this is a good thing. Mummy said, Chloe, I don't understand. Why is Uncle Bobby getting married? Bobby and Jamie love each other, said Mummy. When grown-up people love each other that much, sometimes they get married. I mean, that's not subtly sending a message this is a good thing.
I think that's a way of a mother consoling her daughter who's annoyed that her favorite uncle is distracted and doesn't have time for her. But even if the message were, some people are gay, some people get married.
Wow,
I don't think there's
this guy is so intellectually dishonest
about that. It is a story that is being used to teach students that just as in the 99 of the 100 books that we read about couples, it's a man and a woman, they're also maybe a man and a man.
I mean, why is the Montgomery County Board of Education in this argument running away from what they clearly want to say? They have a view that they want to express on these subjects.
Good
maybe
question,
it's a very good
Justice
view, but they have a
Alito.
definite view, and that's the whole point of this curriculum, is it not?
I'm not running away from anything the board has used to defend this. I think what's in the record is that the board wants to teach civility and respect for difference in the classroom. There is obviously an incidental message in some of these books that these life choices and these lifestyles are worthy of respect. I don't know how you can teach students to respect each other without teaching that. If the book were about, Uncle Bobby's wedding, they get married, and the rest of it is, that was awful. Then there would be a serious equal protection violation in the presentation of that curriculum. So the incidental message that these things ought to be normalized and treated with respect, I think, is simply part of the work that the school is doing in cultivating respect in a pluralistic school.
Well, the plaintiffs here are not asking the school to change its curriculum. They're just saying, look, we want out. Why isn't that feasible? What is the big deal about allowing them to opt out of this?
Hey, thanks, Scott. I appreciate you.
We have the natural experiment of the schools permitting these opt-outs and then finding that it was not administrable. It wasn't true in every school.
Why is it not administrable? They're able to opt out of the health class, right?
The health class is taught discreetly. There's a meeting, mandatory meeting for all parents where they are told exactly what's going to be taught in it, and they're given the option of opting out of the unit of instruction, not the particular.
Well, that's how you define the unit of instruction. You could define the unit of instruction to include the reading of these storybooks.
And that's not compelled as a matter of Maryland state law.
It's not compelled as a matter of state law, but why should it not be compelled as a matter of the free exercise clause of the First Amendment? There's nothing. What is infeasible about doing that?
So again, I think the experience of the schools with respect to these 5 books showed that it was infeasible. And let me give you an example.
Why?
Let's say the school, an exquisitely competent and well-resourced school, is able to say, on Tuesday at 9 o'clock, we're going to read Uncle Bobby's Wedding. We're going to make arrangements for alternative space. We're going to give suitable supervision for our 6-year-olds. And we're going to give them an alternative assignment that accomplishes the same ELA goals. Let's say that happens, right? That they were able to pull off. The next week, someone says, that was my favorite book ever. I'm going to pull it off the shelf and I'm going to ask Alan to sit down and read it with me. What happens then? The teacher can't simply summon a librarian to come to the school, say, those were the kids who opted out of that lesson.
Well, I don't think you're really answering my question.
That's not a lesson plan.
We're going to read Uncle Bobby's Wedding and these other books, but we're going to read it during a period of time that includes the health class, and Children are already able to opt out of that, so they can opt out of reading these books.
I think there's no constitutional obligation to treat these books that introduce people to LGBT characters in a curriculum that is meant to teach about different matters.
I'm not understanding why it's not feasible. The county had an opt-out, you said. Every other school board in the country has opt-outs for all sorts of things. The county has opt-outs for all sorts of things. The other Maryland counties had opt-outs for all sorts of things.
Exactly, Justice
And yet for
Kavanaugh.
this one thing, they changed in mid-year and say no more opt-outs. I'm just not understanding feasibility.
So again, I think what's in the record is that with respect to these books as they were deployed in the classroom,
'Cause
there
they
was
were
high absenteeism in
lazy.
some schools. For example, dozens of students being opted out in.
And then they made an
The average
excuse.
size of an elementary school in Montgomery County is 700 students. So each grade is 125. If you have dozens of students walking out, making arrangements for those students to have adequate space and supervision and alternative instruction, I think is infeasible.
But they do it for all sorts of other opt-outs.
They don't do it for all sorts of other opt-outs. There's a limited universe of things that students can opt out from. The Family Life and Healthy Sexuality curriculum stands alone. It is mandated by the state. It is something where you are able to predict precisely when the curriculum is going to be deployed. There's
It's the most similar substantively to what we have here, and there's an opt-out allowed there. I guess I'm not understanding why Montgomery County School Board stands alone. I think in the country, you can tell me if there's another school board that's done something like this.
I apologize.
Both the kind of books that are being used and prohibiting opt-outs. And I guess I'm just not understanding the whole.
Hang on. Breaking news. We have a tweet from James Lindsay. Are you guys ready? Someone just sent this to me. James says, woke left, parentheses, queer, admitting to weird sex, kid sex, sex with animals, etc. Affirm. Woke right, parentheses, also queer, admitting to racist, hate Jews, violent tendencies, white ethnostate, fascist, and Nazi. Affirm. So edgy and transgressive. It's almost like for the, what is it, almost 2 years now that I've been screaming that James Lindsay doesn't know what queer is. It's almost like James Lindsay has no fucking clue what queer is. That's all. Your regularly scheduled program is back.
Goal, I think, of some of our religion precedents is to look for the win-win, to look for the situation where you can respect the religious beliefs and accommodate the religious beliefs while the state or city or whatever it may be can pursue its goals. And here, they're not asking you to change what's taught in the classroom. They're not asking you to change that at all. A lot of the rhetoric suggests that they might have, that they were trying to do that, but that's not what they're trying to do. They're only seeking to be able to walk out so that they don't have to, the parents don't have their children exposed to these things that are contrary to their own beliefs.
I understand, Your Honor, and there may well be circumstances where a school can or a school district can engineer the win-win. Montgomery County schools try to accomplish an educational goal of introducing these books for a particular purpose. They then attempted to accommodate religious opt-outs in the school, and they weren't able to.
Mr. Schoenfeld, what is that purpose? I mean, I thought the answer to Justice Kavanaugh's question was that the school board was explicit that the books were to be used only to supplement the English language arts curriculum as reading instruction and not to teach about gender or sexuality. So it wasn't as though the books were being introduced.
So why can't you
for the
replace them
purpose
with other
of
books?
enhancing the gender and sexuality component, and therefore people can opt out of that whole thing. It was that we're talking about English here. And in addition to the other kinds of picture books we have on the shelf and we talk about in class, we're going to introduce these books as well. I think that seems pretty infeasible in English when you're talking about reading instruction, that every time this particular kind of book comes out, we have to start letting people leave the classroom.
I agree with you. And I think it goes beyond the readings of the book because, as Justice Sotomayor quoted the language sought in the injunction, I do think that in the context of a classroom where one student is having a discussion with another, or a student comes in from the playground and asks the teacher to define a particular concept, or someone said, my brother's transgender, what does that mean? I think those are all within the scope of the right that the petitioners are urging here and would require the sort of accommodation.
I don't think they're talking about anything student on student. So I disagree with what you just said, that that's within the scope.
I disagree with you. I understand why they might read it that way, but I think if you think about the way a third grade classroom operates,
even Justice
Kavanaugh
has had
there are some
enough.
students sitting in the corner and they say, say,
He's like,
this is a
"This
great
is
book, I'm going to take
dumb."
it off the shelf, and 3 and then 5 and then 9 students gather around to read it, and they say, teacher, I want you to come over and watch us doing that. All of those things, I think, fall within the definition of curriculum at that lower grades. It's mayhem, and the ability of teachers to manage the line between what is curriculum content coming directly from the teacher and coming indirectly from the sort of socialization in the classroom, I think is very hard to draw.
Thank you, Counsel. Justice Thomas?
Chatting with Justice Kavanaugh, you mentioned that the opt-out was unworkable because there were so many students who opted out. What do you mean by that?
So the record is limited on this point, but the Hazel Declaration talks about the fact that principals reported to the school board that there was high absenteeism and gave the example of one school where dozens of students were opting out.
It was that because
So many parents had a problem with this material that it literally created a problem for them in terms of how many students weren't showing up. And the school, instead of saying, hey, maybe we should do something about this. If this many parents are upset about this material, maybe we should just replace this book with another book. Maybe we should try something else. But instead, the school was like, because all of you are upset about this material, we're going to force all your kids to learn it. Congratulations. Wow.
They found them
Great
idea. Or
Great
for religious
idea.
reasons or what?
There are 2 different paragraphs of her declaration that speak to this fact. In that paragraph, it doesn't specify. Elsewhere in the declaration, it makes clear that many of the opt-out requests were not religious in nature. And parents objected, for example, that the age appropriateness of materials have nothing to do with religious prohibitions.
Justice Alito?
Well, we've had a discussion of many different tests and precedents and hypotheticals, but let me just draw back to what's going on in this particular case and get your reaction to this. So you have a case where some of the plaintiffs are devout Muslims. They say, we have a solemn religious obligation to raise our children as Muslims, and that involves certain moral principles that we want to instill in our children, and this school is teaching our children moral principles that are in conflict with ours, and we pay taxes to support the public schools, but we don't have enough money to send our children to private schools, and one of us can't stay home and provide homeschooling. So we just want to be able to take our children out of the part of the instruction that we find objectionable. And what's your response to that? Your response to that is just, well, it's too bad. All right, this is the public school, and the public school can teach what the public school wants.
Alito.
And you don't like that? Well, you can send your children to private schools.
There's no indifference to the religious beliefs of the petitioners in this case. The school did what it could to accommodate those views. There are simply circumstances in which what the petitioner or what any plaintiff recognizes as a burden on their religious belief is not a legally cognizable one, given legal and practical judgment.
Well, it's nice that you say that they respect the parents' religious beliefs, but basically your answer is it's just too bad.
I think
yes,
you've got to send
correct.
Your children to school.
Correct.
You can't afford
That's
to send them
exactly
to
what
any
they're
place except
saying,
the public
Alito.
school. Unlike most of the lawyers who argue cases here, they can send their children to private schools. We may think that that's the way most of the world is, but it's not. It's just too bad.
My answer is that public schools are democratically controlled for a reason. The school board here is democratically elected. The entire process of adopting this curriculum is open and transparent. These books are on review for 30 days before they're even made part of the curriculum. There's then a multi-level appeal process. There's plenty of opportunity for parental insight. And just to draw an analogy to another case from this court, in Bowen versus Roy, there was no dispute that the assignment of a social security number would rob little bird of the snow of her spirit. And this court made the judgment in that case that fully crediting the sincerity of that belief and fully crediting what the parents described as the imposition on their daughter, there was still some breathing room that the government needed to be given to operate in that case.
And you think that providing an opt-out under these circumstances, where you already allow opt-outs from the health class and opt-outs for other things, is comparable to what the plaintiffs were asking for in that case?
I don't think it's comparable in terms of what the plaintiffs were asking for in that case. I do think that under a doctrine where you can't question the sincerity of the beliefs, and so in that case, there was the most dire consequence for little bird of the snow. There's simply no way for the government feasibly to honor the consequences of treating each person's individual religious belief, no matter how sincere, no matter how serious, as a burden that triggers the entire scrutiny apparatus that comes after it.
So your answer to the parents that I talked about, which are real parents here, is just, well, if you don't like this, you got to get involved in politics and run for the school board and change it through politics. But basically, the public schools can do pretty much whatever they think is correct as far as the curriculum is concerned.
I don't agree with the second part of your answer. I don't think it's true that the public schools can do whatever they want. There are clear lines to be drawn. This court has drawn them in cases like Kennedy and Barnett, and Town of Greece in a different context. But I certainly don't think it's true that public schools.
All right, one last question. You say that history is on your side. History and tradition include not only it stretches back to the dawn of American public education that parents can't get opt-outs, right? That's what history shows us.
Correct.
And one of the cases you cite to support that is a decision by the Maine Supreme Court, Donahoe versus Richards, decided in 1854.
Correct.
And what was involved in that case?
In that case involved a Catholic student who did not want to be required to read the King James Bible. I fully credit.
She was expelled.
And she was expelled. And I fully credit that reeks of anti-Catholic bias, as this court has recognized in other contexts. The point in that case.
I understand, but why did you cite that as support for the history that you think supports you?
Because
the history is that public schools did all sorts of things that might violate the Constitution today.
The point was in response to petitioner's invocation of a much more recent history about opt-outs from sex education.
All right, thank you.
Ms. Sotomayor?
Schoenfeld, you talked about the review process for parents. They don't have to run for the school board. It's a fairly complicated 4 levels of review if a parent objects, correct?
Correct. There's a process for adopting curriculum as part of the school materials, as instructional materials at the beginning. And then if parents don't like it, either at that point in time or at some later point in time, given how it's being used, they can appeal it to the school, the deputy superintendent for instruction, the superintendent, the school board.
Listen, I hate to cut this a little bit short, but I do have another show at 9 o'clock with Jennifer. We're going to be watching the second half of the Channel Jesus conversation tonight. And I feel like we get what's going on. I feel like we get it. I just don't want to listen to this guy talk anymore. I'm tired of these stupid questions. I think the Supreme Court is probably going to side with the parents, which I think is going to be a good thing. This guy is an idiot. Ketanji Brown Jackson is an idiot. Samuel Alito is based. Clarence Thomas doesn't give a fuck. I have nothing more to say. It's like parental rights should be absolute. I don't know why this is so difficult to understand. And please homeschool your kids, man. Please homeschool your kids. All right, guys, as a reminder, if you want to support my work exposing and talking about and decoding the far left, head over to my Substack, karlyn.substack.com. Make sure you check out today's clip from the Harvard Activism class that we got into last night. You're going to see what Harvard is actually teaching their students directly with no mistake. That is over on the Substack right now. And we do have another spy stream tomorrow evening at 6:30 p.m. So make sure you sign up as a supporter. So, spy stream is a supporter exclusive. So you have to be a supporter on my main Substack, karlyn.substack.com. You have to, or a member of my locals community, or my Patreon, or a Twitter subscriber, or a YouTube channel member, and you'll be able to come to spy stream with us tomorrow. I will post the credentials out tomorrow. I will probably also do a 5 p.m. stream. It'll be a little bit of an abbreviated one just to talk about stuff, but really the big stream tomorrow is spy stream. So make sure you're a supporter. This is going to be a really good one. We're basically watching the Queers for Palestine lecture for real. There's a real Queers for Palestine lecture going on tomorrow at a major big time school. It's not Harvard, it's a different school. So come tomorrow for spy stream. And you can check that out. All right, guys, I'll be back in a little bit. Jennifer and I are going to go live at 9 p.m. Eastern time. And Disenrage is just a chill show. It's a show where we watch spiritual content and we talk about spiritual content and no politics allowed and no bullshit and no nonsense. And we're going to talk about Jesus and we're going to listen to Jesus impart his wisdom through the use of a channel to us at 9 p.m. And I'm going to go get a sandwich before that because I haven't really eaten today. So I'm going to go grab some dinner. I will see you guys in about a little over half an hour. And or I'll see you tomorrow. Take care, guys. We'll see you soon. Bye.
How are you feeling? How long have you been here?
3 months, May 17th.
And what brought you?
That's difficult to answer. people dislike me because I am not completely like them.
I'm not clear. How is it that playing the piano for people has eventually resulted in your being here in the hospital?
That's difficult to answer.